May I please, Your Lordship? So I'd like to mention item number 47. What is this? The same may be listed after 4 weeks after vacations. Due consent of the other side is there.
Heard, Miss. What? What is your name?
S. Sharma for the appellant.
Heard, Mr. S. Sharma, learned counsel for the appellant, who prays for an adjournment. On what ground you are seeking adjournment?
Lordship, actually, we don't have communication with the
On
party in
the ground
person.
of some personal
We will
difficulties.
establish some.
He submits that he has informed the learned counsel for the respondent regarding his prayer for adjournment, who has no objection to his prayer. The prayer is therefore allowed. Let this matter be listed after 4 weeks.
Vacations.
My lord, I beg to mention item 14, my lord. My lord, senior counsel Y.S. Mandan, my lord, is out of India, my lord. Next week he will be available, my lord. So after 1 week, my lord, I can put
Heard, Mr.
T. Hussain, my lord.
T. Hussain, learned counsel for the petitioner, who prays for an adjournment on the ground that the conducting counsel, Mr. Y.S. Mannan, is out of station. The prayer is allowed. Let this matter be listed after a week on a date to be fixed by registry.
Deep.
Wait, please, Your Lordship. Lordship, with the consent of the other party, Lordship, I beg to mention item number 59, Lordship. And this may come up after vacation.
Heard, Miss
P. Purva, Lordship.
P. Burwa, learned counsel for, you are for?
And for the appellant, Lordship.
This
Your Lordship, I am appearing for respondent number
item
1.
number?
59, Lordship.
Yes, you have anything?
No, Your Lordship, just the name of my senior, R.K. Bhatra, may be reflected in the cause list.
Prays for an adjournment with on the ground of personal difficulty of the conducting counsel. Also heard Miss
A. Biani.
A. Biani, learned counsel for the respondent who does not oppose the prayer. Prayer is allowed. Registry is directed to reflect the name of Mr. R.K. Bhatra as counsel for the respondent in this case henceforth, in the cause list henceforth.
With the consent of the other side, I beg to mention item number 6. So due to certain personal difficulty of the eldest counsel, Mr. N. Alam, for respondent 1. So I pray for adjournment. Will I be taken up day after tomorrow?
Heard, Mr. What is your name?
S. A. Bakhtiar.
Heard, Mr. S. A. Bakhtiar, learned counsel for the, you have informed the other side?
Yes, we
Well,
have
I am
the consent.
there, other side, my lord.
Okay.
I'll fix my lord day after tomorrow. My name is not.
Heard, S. A. Bakhtiar, who prays for an adjournment on the ground of personal difficulty of conducting counsel.
And this counsel.
Also heard Mr. B. Sharma, learned counsel for?
For my lord, petition only.
No, this is an appeal.
Yes, my appellant, my lord.
You are for?
Respondent 1.
I got to respondent. Learned counsel for the respondent who does not opposes the prayer. Hence the prayer is allowed. Let this matter be listed again on 18th of September 2000.
18th.
1/8.
1.
You want it on 18th.
My lord.
When you want it?
My lord, day after tomorrow.
Day after
On it.
Day after tomorrow is 18th.
Your Lordship.
Okay. On 18th.
18th.
My lord.
Obliged.
Obliged.
May it please your lord. My lord, after taking consent from the other side, the petitioner counsel, I beg to mention item number 43. Let the matter come after 2 weeks, your lord. I'm the recently engaged counsel. I have
What is
received
your name?
My name is A. Narzari, your lord.
Heard Mr. A. Nazari, learned counsel for the respondent who seeks for an adjournment. He has submitted that he has obtained the consent of learned counsel for the petitioner in this regard. Considering the submissions, the prayer is allowed. Let this matter be listed
After 2 weeks. Your
after 2 weeks on the date to be fixed by the registry.
Item number 43. Obliged.
Lordship, this item number 53 of the civil matter. Civil matter 53, I think,
53,
53. This matter has been finally heard by his lordship, the Burwa, your lordship, and matter was dictated also to some extent. Wanted one document. So that has been produced by us, you know.
so it is part heard matter,
So not as a finally heard, not part heard.
already heard.
But the matter was dictated also, your lordship, but in the midst, your lordship, there are niche document. So that document we have already filed, your lordship. So our only prayer, your lordship, this matter may be fixed on, listed on Friday next, your lordship, in the same batch, your lordship. D. Burwa, your lordship, Justice D. Burwa.
But if it is not part heard,
Not really, your lordship. The last order may be paid, your lordship. The same thing, your happened. The office actually committed the mistake.
53. Heard Mr. S. Ali, learned counsel for the
Petitioner,
petition appellant,
appellate, your lord.
appellant, who submits that this matter is wrongly listed in the orders column. He also submits that this matter was already finally heard by a coordinate bench of this court within bracket, coordinate bench of this court. But it was not kept part heard. Coordinate bench of this court, stop. Registry to verify and list the matter before appropriate bench.
Lordship on 20th of this month, September, your lord.
No, I will not fix a date. Let the registry finalize because
Or competent bench, your lord.
appropriate bench,
bench,
appropriate bench.
Attention item number 19, lordship. Today's is lordship. And we are required to file amendment in memo, lordship.
Item number?
19, lordship. Can
Yes.
it be immediately after vacation, lordship?
You are for
Appellant, lordship.
what you want to file?
Amendment memo appeal, lordship. Amended.
Heard Mr. Arfcon, learned counsel for the appellant, who submits that the appellant is required to file an application amended memo of appeal in this case. And for this, he prays for some time for same. The prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by the ministry.
Obliged, lordship.
Next legal version. Here, my lord, fat currency and my lord, fat gold was recovered from the custody of the petitioner, my lord. Here, my lord, out of same forwarding, my lord, another accused has approached the honorable court, my lord, and this honorable court has granted bail to that accused, my lord. And another one accused, my lord, from whose possession, my lord, fat gold was recovered, my lord. He was also.
Case diary would be required. Heard Mr.
Last week, my lord, other colleague was granted bail by this honorable court.
Maybe heard Mr. K. Burra, learned counsel for the petitioner, also heard Ms. N. Das, learned the additional public prosecutor. Call for the case diary. Fixing when can you bring?
On 30, lordship.
30 September for case diary.
Currently, my lord, some shorter date, my lord, I am already 58 days in custody, my lord, and other accused were granted bail, my lord, on 49 days, my lord.
26.
Last week, my lord, those matter has come up, my lord, probably, my lord, Shidi may be in the
26
office also,
lord.
my lord.
26.
24th,
26.
24th.
Abhay.
Similar meters are coming up on 19 meters. Let it be along with one. BA number 2735 of 24.
Heard Mr. B. Chaudhary, learned counsel for the petitioner, also heard Ms. Enders. Let the case diary be called for. And let this matter be listed along with
BA number 2735 of 24.
BA number 2735
35 of 2024.
of 24
On 19.
on
19.
19/9/2024.
Oblige.
It's up.
Valid, please. Lordship.
Item 60 from supplementary is
Coming on.
It's on the serial number. Bucking of it.
item 61. Who ordered criminal matters? Who varied item 60?
Serial number.
May I please, your lordship? It was called for it, otherwise.
Serious
case
lordship.
14. Let's finish the FIR.
You have appeared before the. Have you appeared before the investigating?
My instruction is that he appeared.
His
Has-
statement is not available, Lordship. in this
Whether-
meeting. It is not mentioned here, Lordship. Last update is of 6/8/24, where it is mentioned that his custodial integration is necessary.
When have you appeared?
Lordship, I do not know the exact date, but.
You find out the exact
Yes,
date.
Lordship. Yes, Lordship. Updated scheduling again.
We'll take it up tomorrow.
Update up to the city, Lordship.
No,
And I have
no.
to send it. Or
No, you also
I'll
take telephonic information, whether he has appeared or not. Let this case be listed again on heard learned counsel for both the sides. Let this case be listed again on 17/9.
Item 17.
May I please, your lordship? The second time application, lordship.
This
Lordship.
CD is there.
serious, Lordship.
Injury are there, lordship, but all are lordship by blunt weapon. So my humble prayer was lordship, since all are blunt weapons. Section 325 will come, not 326, which is lordship bailable. Lordship, on that count, lordship,
What is the injury?
Previous blunt.
grievous and blunt. If it is blunt, lordship, 25 will come.
If 325 will come, then
It is bailable.
anticipatory bail is not
But there is-
maintainable.
there is some one other section, lordship, 392 is there, but materials are not in ship.
No, what is the ground for second application?
Second-
How the change
Lordship,
situation has
yes, second
changed?
application, when lordship first application was heard, lordship passed the order subsequently, lordship after hearing, and learned PPS produced the CD. So during hearing, lordship, learned PPS said that injuries are there, grievous injury, but on blunt report. But this
Not
also-
blunt.
Blunt, yes. So lordship has held that since grievous injury is there, so two were allowed, lordship, and four applications was rejected. So lordship, my humble prayer, since lordship 325 is there, others materials are not there. Regarding 392, no materials is there. On that one, lordship may consider it. 392, lordship has been integrated in the affair, but no materials is there in the city.
No, but it was observed that there are incriminating material against.
Incriminating, yes, lordship, regarding injuries, implicating material. And initially, lordship, when matter was heard, lordship, it was also submitted by landed people that yes, injury was there. But order lordship, blunt weapon was there, not the sir. So 325 will not that much. And lordship, others is that petition number 1 is a 62 years old lordship. And cultivator, so even he cannot see lordship properly.
And others are also of same family members. Some dispute regarding lordship insisted property was there. On that count, lordship, this affair has been lost.
No, it is not a case because once a decision has been taken, why the court should take,
Lordship, that is why lordship, I'm honestly submitting lordship. When matter was heard, learned people also.
no, that is your submission, but order sheet does not reflect.
That is what lordship, I'm saying. And two other grounds, lordship will find a paragraph number 6 of my petition. Page 6.
No. What is the ground?
Lords. Well, also the grounds regarding the second application, lordship, is that the petitioner number 1 is a 62 years old also.
But
And
there, he was 62 years old on the first occasion also.
Yes, lordship. First
There's
opinion
no
also it
page
was
for
there.
lordship.
And no, lordship, what apparently lordship, the basis of the petitioner is there. Since lordship, in the CD, it reveals that although there is a lordship grievous injury, lordship has only taken into consideration that grievous injury is there. But
Yes.
yes,
No, but after considering everything,
no, lordship, after
an observation was,
lordship, if
Yes,
the order was passed, lordship, in the chamber itself, lordship, not in open court. So lordship, I was in court, lordship, I submitted that since grievous injury, although grievous injury is there, but blunt report. That order was not considered. The first
Yeah.
order was passed lordship in lordship's chamber, not in open court. So lordship might be lordship there was because of passing the order in chamber, lordship might be there are some gapping between PP submission and lordship's findings. Lordship.
no.
And lordship, considering the fact that there are incriminating material
Incriminating material is there.
against the
Lordship.
petitioner number 1.
I am not denying lordship. Incriminating material
Then
is there.
this is not a case for second
No, second
anticipation.
bail application because yes, lordship, there are other options also there, lordship, to appeal or to review the order. I have not gone through because lordship since
The
lordship. has not-
review is not available.
Lordship, that order could be reviewed because lordship, here happens is there learned type PP at the time of hearing lordship just submitted a blunt, which blunt report. So that order lordship has not considered. So lordship, simple case lordship, otherwise lordship, there is no case at all. It's a case of regarding lordship dispute of land. I have all mentioned everything lordship, the title sheet is going on.
No, how you will overcome para 12 of the earlier order? Paragraph number,
Considering the fact that there are incriminating materials is there. lordship.
that
I'm
is
not denying.
enough to reject.
Lordship, incriminating material regarding lordship has to go by the the section incorporated by the IO. Lordship will see the affair that section has been lordship incorporated at page 15 lordship.
No, Mr. Kolita.
All the witnesses categorically should be implicated.
When in anticipatory bail after perusing the case diary, court has,
Lordship, I am not denying everything lordship.
then
only
for
seeing that, lordship.
reconsideration,
Only lordship that type, lordship.
some new facts, new situation must have a,
Lordship, why I am
Hmm.
submitting lordship, new situation is that lordship, when lordship heard the matter. Lordship directed the PP to go by the SCD and to lordship to give the CD to your lordship. Accordingly, lordship
Yes,
passed the order
lordship,
in
after
a
phase-
chamber, not in open court. Had it been in open court, lordship, I would have got a chance to lordship point out that still there is a grievous injury, but blunt report, then lordship 326 will not come. But that opposition lordship is present, I did not lordship get. So lordship, that is why lordship, simple prayer lordship, otherwise there is no case at all.
This is not. a
three
ground.
ninety-two.
392, nothing is there, lordship. Had it been open court, lordship, I could have get a chance, lordship, to raise my objection that since 25 will come, then all are available section. That must lordship may consider, otherwise lordship, there is no case. All are false allegations, lordship, only to grab the ancestral property of this.
No,
petitioner.
that is also not a ground for second anticipatory bail.
If lordship go by minusly, then lordship, there is no case. But what I am saying, lordship, because the order was passed in chamber, I could not get chance to
No.
submit that.
You have to challenge on the basis of the on the basis of the earlier order pass.
Earlier order, that is what I am saying, earlier order, the lordship has only held that there is incriminating materials. What incriminating material that has to be lordship ascertained?
You have to lay down
No,
the
lordship, otherwise there is no case.
grounds for a second anticipatory bail
No,
application.
lordship. There is no such straightjacket formula that every grounds lordship has to be specific. Because lordship, it is anticipatory bail, is a question of liberty of the petitioner, right of the petitioner. So lordship has rejected the prayer of for person lordship without considering that since although the injuries are there or grievous injury, but it was on blunt report. So lordship has not considered that aspect lordship. Lordship is absolutely right that I have to point out the for grounds for second application. That is absolutely, I am admitting Lordship.
What are the grounds?
The grounds is Lordship that since Lordship code, PP submitted the code that it was.
That cannot be a ground.
Lordship, that is also ground, if Lordship fine, otherwise, Lordship,
That is before a higher forum, not before the same forum.
no, Lordship, because if had this oral been passed in open court, I could have Lordship raised that objection.
Heard Mr. J. Kalita, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973 has been filed by the petitioners, namely 1, 2, 3, and 4, who are apprehending arrests in connection with Agomoni PS case number 33/2024 under section 143/147/147/323/325/326/392 of the Indian Penal Code. Stop. It is pertinent to mention herein that this is for the second time the petitioners have approached this court seeking anticipatory bail in connection with Agomoni PS case number 33/2024. Stop. The earlier application filed by the petitioners, that is which was registered as AB case number 1725/2024, has been rejected, was rejected by order dated 18/7/2024 on the ground that there are incriminating materials against the petitioners in the case diary. And therefore it was not felt at that time that a favorable order under section 438 of the Code of Criminal Procedure may be issued in favor of the petitioners. In the present application, the petitioner has not raised any new grounds for
The new
approaching.
grounds I have raised, Lordship, that
Where?
is considered.
Where? Where?
Lordship, at page, paragraph number Lordship 6. Whether Lordship will consider or not, that will up to
Where?
Lordship. Paragraph number 6 is my new grounds, Lordship.
What is the ground?
Lordship. So may I read the grounds, Lordship.
He is ill
Lordship.
against petitioner number 1. And since when he is ill?
Lordship, from last few years, Lordship, his condition is that. But Lordship, first petition, Lordship, it was not
On
met.
the ground that the petitioner number 1 is ailing and has suffered loss of eyesight. Stop. However, learned counsel for the petitioner submits that the petitioner number 1 has been suffering from the said ailment since last many years. Stop. No other new ground has been mentioned for approaching this court for the second time. On the other hand, learned additional public prosecutor has produced the case diary of Agomoni PS case number 33/2024 and has submitted that there are sufficient incriminating materials against the petitioner in the case diary, and the petitioner in approaching this court for the second time has not mentioned any new grounds. So, I have considered the submissions made by learned counsel for the petitioner as well as learned additional public prosecutor and has perused the materials available on record. It appears that the earlier application, which was filed by the petitioners, was rejected by this court after perusal of the case diary. And it was observed in the said order that there are incriminating materials against the petitioners which does not justify issuance of a favorable order under section 438 of the Code of Criminal Procedure, 1973 against the petitioners. It appears that the petitioner has mentioned only one new ground for approaching before the court for the second time, that is, the petitioner number 1 is suffering from ailment. However, on perusal of the statement made in paragraph number 6 of the anticipatory bail application, it appears that he has been suffering from the said ailment since many years. So this cannot be treated as a new ground. Moreover, learned counsel for the petitioner has also submitted that though the victim in this case has sustained, how many victims are there? Has sustained grievous injuries. The nature of injury is blunt. No, what is the report?
Lordship. Statement of accused are there, Lordship.
No, the medical injury report.
Medical report, Lordship. Grievous, blunt,
The injury has been caused by a blunt weapon. And therefore, learned counsel for the petitioner has submitted that the case would not fall under section 326, but under section 325 of the Indian Penal Code only. However, it appears that this court had on earlier occasion had rejected the anticipatory bail application of the petitioners after perusal of the case diary and found the case not fit for grant of anticipatory bail to the petitioners. The petitioners have not been able to satisfy this court any change of circumstances or any new ground for approaching this court for the second time for grant of anticipatory bail. Therefore, this court is not inclined to grant anticipatory bail on the second application filed by the petitioners. For above reasons, this anticipatory bail application is dismissed.
Because of
Send-
wrong communication, Lordship, my client is suffering loss.
Send back the
Despite there is a good order, Lordship, my client is suffering because of
Send-
wrong communication loss.
send back the case diary.
Obliged, Lordship.
May I please, Your Lordship? Your Lordship, in this case. I'm behind the bar for 444 days, Your Lordship. Your Lordship, the affair is at page 14, page 17.
Lordship 364 speaks for production. Up to date status report is required. Can copy, Lordship.
This is a charge sheeted case.
Yes.
Charge sheeted case, Your
Yes,
Lordship.
Lordship.
It is a case under NDPS Act.
Yes, Your Lordship. Your Lordship, in this case, Your Lordship, there is a 50 witnesses.
Charges.
No,
That I
what-
have already said.
What is your ground?
My ground, your lordship, the contraband item is not recovered from me. That was recovered from the abandoned vehicles. So directly, it is not in my seize, your lordships. Second, your lordships, I am in Jehanavar for 444 days, your lordship.
That is not long.
Your lordships.
That
It's
is
a
not
law.
long.
And moreover, your lordship, there is no possibility of, it will be completed, trial will be completed within short duration, your lordship. It may take 5 and 6 years because your lordship, the charge sheet, if your
No,
lordship.
no, that you do need not to
50
make,
witnesses, your lordships.
maybe you.
50 witnesses.
440,
4 days, your lordship.
that is 1 year and how many months?
1 year, your lordships, around 3 months. 3 months, your lordship.
And other ground is?
Other ground is, your lordships, this contraband is not in my possession, your lordships. It was not recovered from my possessions.
From where it was found?
It was found from the, your lordships, page 19, your lordship, the FIR.
Miss Das, you go through from where
It is
contraband was?
contraband found from the abandoned vehicles, your lordships. And as I am there, your lordships, in and around that, your lordship, so they arrested me, saying that this contraband, I am the drug peddlers and contraband linked to me, your lordships. This is the case. And
No, now charge sheet has been filed.
your lordships.
Yes, lordship.
Witness statements were recorded. Is it a case where nobody has incriminated you in this case?
Your lordships, that I cannot say, your lordship, it is not implemented, but there is no evidence at all, as of now. No evidence was happened, your lordships.
Lordship, let the status case record.
No, you go
record,
through
lordship.
the record and make submission. Is there any
Lordship, I have go to, but statement of PWDs are not there, lordship.
No, there is no evidence at all, your lordships. Nothing happens.
case diary? The scan copy of case diary is there or not?
Lordship,
Case diary is there.
it's there,
You go through the case diary.
lordship.
Is there any, is what Mr. Jha is saying that there is no evidence? Is it a case
Lordship.
or whether something is there?
Yes.
If something is there, his bail will be rejected.
Lordship,
If nothing is there, he may get a bail.
lordship.
Your
Yeah.
lordships, regarding that, your lordship, if I am in not, the contraband not directly from seized from my
Let her
possession.
go through. How much time will
And-
you require?
To lordship,
Today itself?
tomorrow, lordship.
Okay. Heard Mr. N. Jha, learned counsel for the petitioner. Also heard Ms. N. Das. Tomorrow you will be there.
Your day after tomorrow, it may be fixed, your lordship.
Ms. N. Das, learned additional public prosecutor, who submits that he needs some time to go through the scanned copy of the case records before making submissions in this case. The prayer is allowed. Let this matter be listed again on 18th of September 2020.
My pleasure, lordship, 60 and 61 out of same lordship. 439 application, lordship. Earlier, LCA was called for. They are inside the jail since 19 to 2022, lordship.
Who is appearing for NCP? You're ready?
No, your lordship, LCR was called for, but it has not come into the
Has been
record.
received by the registry, lordship, to our information, but this big,
Let it be tagged.
let it be tagged with matter, lordship.
Heard Ms. S.K. Nargis, learned counsel for the petitioners. Also heard Mr.
KJN.
K. Jain, learned counsel appearing for NCB. It appears that the scanned copy of the LCR, which was scanned copy of the case record, which was called for, has not yet been tagged with the, has not yet been, which says that it has not been received.
It is received on Friday, last Friday, because.
But
before-
office note is saying
Your
that
lordship, we inquired in the registry, lordship, today morning, lordship.
On perusal of the office note dated 13/9/2024, it appears that the scanned copy of the case record has not yet been received by the registry. Stop. However, Ms. S.K. Nargis submitted that she has inquired from the registry concerned section of the registry and came to know that the scanned copy has already been arrived
On last Friday.
on last Friday. Stop. Let the registry to verify and place the scan copy along with the record if it has already arrived. Let this matter be listed
On
and
Friday, Lordship, if possible.
Lordship, can it be fixed on Monday?
let it be on Monday. On Monday, that is 23rd,
Deeply on
Much on.
both the matters. Yes.
60,
Do
60,
both the matters can be taken, Lordship.
60 and 61 same orders.
Yes.
Much
Deeply on.
Order item 56.
Khichdi
That
kari
is your
this.
lordship. Here, lordship was pleased to grant the privilege of pre-arrest bail to the petitioner. Lordship will find lordship's order is in annexure 1, page 11. And the relevant is in page 15, lordship, where we are before your lordship. Lordship has given a condition that the petitioner shall not leave the jurisdiction of the state of Assam without prior leave from the investigating officer. Now, what happened, lordship, the petitioner's father has fallen sick. I have given some documents, lordship, I have annexed some documents. Lordship will find in annexure 2 series from page number 17 to page number 20. These are the medical documents of the petitioner. Petitioner's father. Petitioner is actually a native of Begusarai, lordship, in Bihar. So he was residing here in Guwahati for the purpose of his job only. Now, lordship will kindly see that as per the order passed by this honorable court, petitioner wrote a letter to the IO that your lordship will find in annexure 3, page 24. With due respect, I may be allowed to visit Bihar. My old father, aged 71 years, who is currently ill. My father has been diagnosed with various illness from long time and his condition has deteriorated to point out where my presence is urgently required to support him and assist.
Then
his
what
care.
happened?
Then lordship will kindly come to page number 25. He denied. He denied, although I participated in all investigations. So my humble submission before lordship for just a small modification that it may be subject to the approval by the special judge Assam. This order may kindly be modified to the extent that the petitioner shall not leave the jurisdiction of Assam without prior approval from the special judge Assam.
Okay.
That is my prayer.
Heard Mr. A. Bhattacharjee. Any objection? Also heard Ms. N. Das, learned additional public prosecutor. This interlocutory application has been filed by the petitioner, Shri Santosh Kumar Chaudhary, in connection with
AB number
anticipated bail
1012.
case number 1012/2024. Now, seeking certain modifications in the said of condition number 2 mentioned in the said order. Stop. Learned counsel for the petitioner has submitted that the petitioner was allowed to go on anticipatory bail by this court by order dated 24/2024, passed in AB case number 1012/2024. With certain conditions. And the condition number 2 imposed mentioned in the said order was that the petitioner shall not leave the jurisdiction of the state of Assam without the prior leave of the investigating officer. Learned counsel for the petitioner has submitted that the petitioner is a permanent resident of Begusarai district of the state of Bihar, and his father, who is a resident of the said place, has been suffering from coronary artery disease and other ailment and has fallen ill. Stop. Therefore, the petitioner is required to go to the said place to meet his ailing father. Stop. Learned counsel for the petitioner has submitted that in this respect, in pursuant to the directions of this court, the petitioner had filed an application on 19/6/2024 before the investigating officer. However, the said application has been rejected by the investigating officer on the ground that the investigation of the case is at very crucial stage. Stop.
I have thereafter appeared, Lordship.
Learned counsel
called me,
for
I
the
appeared.
learned counsel for the petitioner has submitted that thereafter also the petitioner has appeared before the investigating officer and has cooperated in the investigation. Learned counsel for the petitioner has also submitted that the condition imposed on condition number 2 attached to the bail order, which was granted in favor of the petitioner, may be modified to the extent that instead of seeking leave of the investigating officer, the petitioner may be allowed to seek leave of learned special judge
Assam.
Assam before leaving the special judge Assam.
Yes, Lordship. He is in the jurisdiction, Lordship. CM's vigilance come under the jurisdiction of Special Judge Assam.
Okay. Before leaving the jurisdiction of the state of Assam. Stop. I have I have considered the submissions made by learned counsel for both the sides. It appears that the prayer made by the petitioner to leave the state of Assam by the petitioner to meet his ailing father was rejected by the investigating officer in the month of June. Stop. Now we are in the month of September.
Now also he is refusing, Lordship. Although he has not given anything in writing, but he is
Stop.
refusing.
The petitioner is required to continuously cooperate with the investigating officer in the investigation, which the petitioners is undertaking to do. Stop.
This petition, in fact, Lordship, was filed at that period of time only, but it was not listed before this court. Lordship will find it was filed on 9th August 2024.
Okay.
Page number 10. Lordship.
After considering the facts and circumstances of the, I have also gone through the connection documents submitted by the petitioner in support of his contention that his father is suffering from
Several ailments.
several ailments. Stop. Considering the ailments of the father and the facts and circumstances of this case, this court is of considered opinion that the condition number 2 attached to the order dated 24/2024 passed in AB number 1012/2024 is required to be modified. Stop. Hence, same is modified as hereunder. The petitioner shall not leave the jurisdiction within inverted comma 30%. petitioner shall not leave the jurisdiction of the state of Assam without prior leave of the learned special judge, Assam. Stop. And if such a leave is granted by learned special judge, the information of the same shall also be given to the
Your concern,
investigating officer of the case,
Lordship.
and the petitioner shall continue to cooperate with the investigation. With above observation, this interlocutory application is disposed of.
Deployment.
This, IA
ये सब मजद क्यों मत लिया से? Yes,
This IA is for restoration, my lord.
restoration of what?
Restorations of IA number, restoration IA number 677/24.
Where is the provision for restoration?
Restoration, my lord, that I have filed it, my lord, under section 528 of BNSS. Inherent powers of the High Court.
You file a fresh IA, no restoration.
My lord, the reason is that on two occasions, my lord, my name was not shown in the court case, so I overlooked. On two occasions, can you see that the reason, my
No,
lord?
why that IA, earlier IA was filed?
Earlier, I was filed, my lord. At that time, my lord, NBW was issued, which was not annexed, my lord. Subsequently, for modification of the order, my lord, of that order, so I was filed. For modification of earlier order, because NBW was not annexed, because someone was annexed. Subsequently,
Modification of the order
orders, yes,
by criminal court.
by your lordship's order, my lord.
Oh,
That-
the anticipatory bail order.
Anticipated, my lord.
You file a fresh IA instead of restoration. There is no provision for restoration. Or you show me a provision.
I probably.
You can always file a fresh IA for seeking modification. If
Then, my lord, I'll file a fresh.
this one with
Uh,
dismissing, I'm dismissing it.
one time I would like to withdraw this with a liberty to file a fresh.
Third, Mr. H.R. Chaudhary, learned counsel for the petitioner. Also, Ms. N. Das, learned additional public prosecutor. This interlocutory application is dismissed on withdrawal.
My lord, the matter will adjourn for the day, my lord, some personal difficulties, my lord. Will come after the vacation, my lord, for the application, my lord.
Third, Mr.
VK Borwa, my lord.
V.K. Borwa, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of the conducting counsel. The prayer is allowed. Let this matter be listed after 2 weeks on the date of the
Hello.
fixed presence.
Or I am appearing for the respondent.
Who is for the petitioners?
C. Goswami. There is urgency in the matter, my lord.
What is to be done?
My lord, my execution has been stayed, my lord.
No, what is your submission now? Petitioner is not there.
On earlier occasion, my lord, they were absent, my lord.
So you make your submission. What should I do?
Your lordship may take up after some time, my lord, I will inform you.
Not to dismiss it.
Yes, my lord.
You don't want its dismissal.
Because otherwise, if your lordship dismiss it, my lord, they will file an application for
Okay, we'll take it after some time.
after some time, my lord.
So this is regular first appeal, my lord, against the judgment.
My lord,
The appellants may be directed to provide us with the copy of the RFA, because after the delay was condoned,
Thereafter, it is registered as a regular first appeal, but no copy, nothing has been provided to us.
Okay.
So,
Heard Mr. G. N. Sahewala, learned senior counsel assisted by Ms. D.J. Sahewala, learned counsel for the appellant. This appeal under Order 41, Rule 1 of the Code of Civil Procedure has been filed by the appellants
Against judgment and decree, it is 7/4/20.
impugning the judgment and decree dated 7/4/2021 passed by learned civil judge Karimganj in title suit number 29/2015, whereby the suit of the respondents was decreed. Stop. You are appearing for all the respondents.
my lord, I am preparing for all the respondents, yes.
This appeal is admitted. Let this. Let
No
no-
annexure. No annexure. No annexure.
The Mr. What is your name? Mr. D. Nandi, learned counsel, has appeared for all the respondents. Therefore, no formal notice need to be sent to the respondent. Let the case record of title suit number 29/2015 be called for from the learned trial court.
My lord, there are, it appears from the memo of appeal, there are pro forma respondents also there. The pro forma respondents,
Their names may be, I think, stuck off, my lord.
No, once you take step,
All right.
stop. The appellant shall take steps for
Proper number 5 and 6.
for issuance of notice upon pro forma respondent number 5 and 6 by registered post with AD as well as by usual mode within 7 days from the date of this order,
Right.
returnable after 4 weeks. List this matter after 4 weeks.
for admission, let it come.
For admission,
No, it will be for order.
Order.
Because notices will go to the pro forma respondents. So it will come on orders.
we are admitting
Yes.
we have admitted the appeal.
My lord, I may be allowed to submit my part. I am
First
yet
appeal,
to
regular first
receive the-
appeal.
No, maybe. It is regular first appeal. But what are the grounds and all? Let me go through you. Let it come up for admission. Because they are yet to provide me the copy of the annexures.
Respondent has nothing to say, my lord, so far admission of the first appeal is concerned.
First appeal, statutory right is
It
there.
was admitted by the district judge. Thereafter-
Because delay has been condoned.
Yes,
Delay has been filed. That is.
so it may be.
So list it after 4 weeks.
Kindly provide me the annexures. Deeply of this.
Lordship, kindly the matter may be passed over for timing. As a senior lex in our.
I'm appearing for respondent number 4. Sorry, both the respondents. Now, LCR was called for. And it appears that LCR has already come. So maybe posted on Thursday, and it can be disposed of. Very small matter, madam. Hardly 15-20 minutes.
Who is for the,
They're seeking time for
who
the
is
time.
for the
Time being.
petitioner?
For time being. As
No.
a senior lex in our.
Who is your senior?
J. Galita.
No, we are fixing it on, next
Thursday,
Tuesday,
madam.
not this Thursday. We have already fixed it. Tuesday, next Tuesday.
Can be disposed of. Yes.
Heard Mr. What is your name?
Yes, Kathak.
S. Kathar, learned counsel for the petitioner. Also heard Mr. What is your name? What is your name?
Enough.
In Learned Council for the all the how many respondents are there?
Two respondents. ma'am.
Both the,
I'm representing both.
both the respondents. Learned, the, on perusal of the office note dated 30/8/2024, it appears that the trial court records have arrived. Stop. Learned Counsel for the respondent submits that the matter may be heard and disposed of as the trial court records are available. Stop. Let this matter be listed again on on 24th September, on which day endeavor shall be made to finally dispose of the matter.
Much appreciated.
Items 8 and 9 are corrected, led by Mr. S.K. Singh, Learned Senior Counsel. These two matters be taken up at 2 minutes today.
2.
Yes.
Mhm.
That case, my lord, after some time, I will take a chance. He's in on legs in another court, my lord. Take some time.
No, it will be for who is for the other side?
They have not appeared in spite of service of notice.
It
That
is
has
for
been
final
recorded.
disposal.
Otherwise for disposal on. Won't take much time. Perhaps not.
No, then we'll take it after the other matters are over.
Good. At the end of the book.
Okay.
Good. Item 10.
Yes, Mr. Sundar.
But here in this case, notice was issued and we have served notice by Dosti and Lordship has taken note of that of my lord service by order dated 22/7/2024. Notice is deemed served. So my lord, we feel that here for adjudication of the matter, record is necessary. Record, there was my lord, they wants to reopen the title suit which has been disposed of.
Which
then-
order you are impugning?
My lord, at page 91.
What is that order?
Notice was issued the title suit, they have not appeared despite service of notice. Then my lord, title execution, in title execution they have appeared and filed Ukalatman petition that they will file objection. Later on they remain absent. When the title execution is, my lord, is about to complete, my lord, they file a miscase in the my lord, they file a petition in the title suit.
Title suit is,
My lord, title suit for reopening the title suit, and they wants to vacate the judgment and decree in the title suit. No?
then what has happened?
My lord, then my lord, they filed the miscase for condonation in the petition for vacating the judgment, and that condonation petition is allowed. Therefore, my lord, we are
Against that order in condonation application.
my lord, the condonation petition in filing their petition for vacating the judgment, ex parte judgment, then it was allowed. So, my lord, we feel that the titles, record of the title suit as well as the my lord, title execution, both the records is required. My lord.
You are the decree holder.
My lord, we are the decree holder. We are decree holder. The title suit was decreed. After serving notice, they have not appeared. When a decision was passed in ex parte, title execution proceeded. In title execution, they have appeared. They filed petition, paying for time to file objection. Thereafter, they have remained absent. Title execution in the meantime completed. Then they file a miscase for vacating the ex parte judgment in the title suit, along with a condonation petition. And that condonation petition has been allowed by this impugnator. We are against that. This is the background of the case.
And has already been mutated.
My lord, already my lord, title execution has been my lord, completed and has been mutated in our name.
No, but our jurisdiction under 227 is limited. The delay was condoned after considering the facts.
My lord, the delay was condoned on a petition which is
Okay,
to
okay.
total
We-
suppression of facts.
Okay, we are heard Mr. S.H. Sigdar, learned counsel for the petitioner. None has appeared for the respondents. Learned counsel for the petitioner submits that for consideration of the instant civil revision application, perusal of the records of which records? Ms.
My
J.
lord, records in
Ms. J case number 88/2022, as well as
my lord, an execution also record of the title execution.
and record of title execution case number which
Title execution case number 2/2019 in the same court.
2/2019 pending before the Court of London Civil Justice Senior Division would be necessary. Let the scanned copy of the case record be called for. From the said court. Let this matter be listed at registry to take steps for requisitioning the aforesaid records. Let this matter be listed again on
After vacation. Any day after vacation.
after ensuing puja vacations on a date to be fixed by registry.
My lord, Indian may continue.
The interim shall continue till its date.
Deeply obliged.
Lordship, in this case, appellant challenges the impugned part of the judgment and order dated 12/5/2020 to pass in MSC case number 349 million. The Lordship, whereby Lord, claim petition allowed and insurance company is directed to pay and thereafter recover from the owner. Here the appellant is the owner. My lord. Lordship, operative purpose at page 71, my lord, 34, my lord, paragraph 34.
No, we issue notice in this.
Lordship,
You have deposited the cost
Lordship,
which was imposed on you
Lordship,
while condoning the delay.
yes.
Heard Mr.
M.
M.
Mohan.
M. Mohanto, learned counsel for the appellant. This appeal under section 173/173 of the Motor Vehicles Act, 1988 has been filed by the appellant Madhurjo Dhekial Fakun. Your claim petition was dismissed.
No, my lord. Here, my lord, appellant is the owner, my lord. And during adjudication, my lord,
You were
uh,
imposed liability to pay the
Lordship, and during adjudication, my lord,
impugning the judgment and award dated 12/5/2022.
my lord, here, my lord, direction was to pay the amount first by the insurance company and thereafter recover
Recovery.
from me. My lord.
Okay.
Lordship and all the insurance company already deposited the pay the amount and now they file a petition under section 174 for recovery. Lordship will fine at the pay.
Now what you are impugning?
Lordship.
What you are challenging?
Lordship, I am challenging impugned part whereby liberty was granted to the insurance company to recover the amount.
That part of the
Lordship.
original
Lordship,
order,
that part is Lordship will find at page
impugning the
30,
order,
71 million. Page 71.
award slash and impugning the judgment/award dated 12/5/2022 passed by learned member, Motor Accident Claims Tribunal in MSC case number 349/2016 to the extent whereby the insurance company was directed to recover the awarded amount after paying the same to the claimant from the present appellant. Stop. Issue notice to the respondents. The petitioner, the appellant shall take steps for issuance of notice to the upon the respondents by registered post with AD as well as by the usual mode within 7 days from the date of this order, returnable after 4 weeks. Let the case record of MSC case number 349/2016 be called for from the concerned tribunal, the registry to take steps for requisitioning the records. Let this matter be listed after 4 weeks.
Lordship, I haven't prepared for statement. There is a miscase, my lord. Since proceedings recovery or proceeding or recovery is going on, my lord. Until and unless that has been state, my lord, will be.
No, after, what is the ground for stay?
Lordship, because
We are issuing notice here also.
Lordship.
This interlocutor.
Otherwise, I have to proceeding is going on before the tribunal, my lord.
You have appeared in the
Lordship,
execution
Lordship,
proceeding.
Lordship, I have
In execution proceedings, you
Lordship
have
appeared
appeared.
and informed the honorable tribunal regarding filing of this.
No, let us issue notice to the insurance company. At least let the insurance company appear.
Otherwise, I have to again appear before.
Appearance is. But
If lordship will find an order, my lord, then at 77, my lord, then the appearance along with payment of the order amount, my lord. And because since
no, on the next date after service of notice. This application, this interlocutory application has been filed by the applicant/appellant for staying the operation of the judgment and order dated 12/5/2022 passed by learned member, motor accident claims tribunal, Nagaon, in MSC case number 349/2016 to the extent whereby the insurance company was given a liberty to recover the awarded amount after paying the same to the claimant from the present applicant. Issue notice to the opposite parties. The petitioner shall take steps for issuance of notice to the opposite party by registered post with AD as well as by usual mode. Within 7 days from the date of this order, returnable after 4 weeks. The prayer for interim relief would be considered only after due service of notice on the insurance company. Please accordingly.
If it has been had by the insurance company on the ground, that lots of deceased was the son of the claimant. He was 18 years. He was driving a motorcycle of his father without license. And the tribunal has not considered these facts. And he was driving the motorcycle without license and he died. And tribunal has awarded 14 lakhs. So Lordship may admit this appeal, will deposit 50% at this stage.
50%.
And this.
What is the ground?
Ground is Lordship, the deceased was driving a scooter, motorcycle without having a license in the road.
Without license.
Without license. Motorcycle of his father in the national highway, and he made the accident. And claim has been filed under section 166. No eyewitness examined. Secondly, Lordship, the dependency has been considered by the tribunal considering national income. Admittedly, he's a student, and mother was 44 years. Husband is there, father is there. So there is no question of dependency also. Other conventional that they will get the compensation, everything, but not contributing negligence has not been considered at all by the tribunal. These are the grounds. And Supreme Court has already, Lordship is aware that Supreme Court in Wada's case, the Supreme Court has categorically stated in case of minor children or either up to 18 years or 15 years, what will be the compensation. I'm not going to guess at this stage at the This at a hearing.
It is not in pursuant to that direction.
No,
Heard Mr. S. K. Goswami, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicles Act, 1988, has been filed by the appellant insurance company, impugning the judgment and award dated 5/2/2024, passed by learned member, Motor Accident Claims Tribunal, Nagaon, in MSC case number 279/2022, whereby the insurance company was directed to pay an award of rupees
14 lakhs.
14,37,800 to the complainant along with the interest. Issue notice to the respondents. The applicant shall take the appellant shall take steps for issuance of notice to the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Let this matter be listed after 4 weeks. Next, interlocutory application. This interlocutory application has been filed by the applicant, applicant insurance company for stay of the execution of the impugned judgment and award dated 5/2/2024, passed by learned Motor Accident Claims Tribunal. Agor case to this appeal is admitted. By Motor Accident Claims Tribunal, Nagaon, in MSC case number 279/2022. Stop. Whereby the applicant was directed to pay an award of rupees 14 lakhs 37,800 to the claimant respondents, claimant's opposite party. Stop. The applicant has filed a connected appeal impugning the aforesaid judgment and award, which is registered as MSC appeal number 376/2024, which has already been admitted and notices are issued to the respondents in that case. Stop. Considering the grounds mentioned in the interlocutory application, the notice to the opposite party is dispensed with and the interlocutory application is allowed subject to the payment of 50% of the
Subject to deposit of
subject to deposit of 50% of the awarded amount by the applicant to the registry of this court within a period of
4 weeks.
4 weeks from the date of this order. This
Case may be disposed of. They can
This-
file an application for withdrawal.
this interlocutory application is accordingly disposed of.
Obliged.
Make business, your lordship. Lordship, this is a statutory appeal. What happened, lordship, in this case? The deceased, she jumped out of the vehicle and her legs were under the wheel and she died. So ration negligence itself, her ration negligence was also there. She jumped out of the vehicle. And lordship, another thing is that
Why she jumped?
why she jumped? Because there was a brake failure.
Okay.
That's why she jumped. out of the vehicle.
She fell out of the way.
No, jumped. It is in the evidence as well as in the judgment also, Lordship, and take Lordship to,
Okay,
uh,
okay.
it is there, Lordship.
So
Paragraph.
out of fear.
Maybe out of fear.
Yeah.
That is one ground. Secondly, Lordship, she did not die because of the injuries, Lordship. Why she died was Exhibit 7 death certificate. They did not exhibit the postmortem report in the case, Lordship, because then it would have been revealed that reason of death. But the death certificate, which is Exhibit 7, Lordship, it shows that her death was due to cardiorespiratory arrest sequel to brain embolism DVT. Brain embolism is, Lordship, I mentioned in my ground C, is a blockage in an artery within the brain or in an artery that feeds oxygenated blood into the brain. So, Lordship, basically, the death due to the accident is also not proved. And since they did not exhibit the PM report, Lordship. And other than that, we have other on quantum also.
R.D. Majumdar, Learned Counsel for the appeals. This appeal under section 173 of the Motor Vehicles Act 1988 has been filed by the appellant insurance company, impugning the judgment and award dated 4/11/2022, passed by learned member, Motor Accident Claims Tribunal, Achar, Silchar in MSC case number 81/2013 stuff. I have perused the grounds taken by the appellant in the memo of appeal. This appeal is admitted. Stop. Issue notice to the respondents. Stop. The appellant shall take steps for issuance of notice to the respondents by registered post with AD.
Lordship,
As-
5 and 6 are appearing, Lordship. We will give them by hand. The names are also shown, Lordship, in the cause list. 1 to 4 will take steps, Lordship. Because they did not appear in the delay petition also, Lordship. 1 to 4, the claimants.
Yeah. Last one. To the respondent number 1 to 4 by registered post with AD as well as by usual mode. Within 7 days from the date of this order. And in 7 days from the date of this order, returnable after 4 weeks. As regards respondent number 5 and 6 are concerned, it appears that name of their engaged counsel has been reflected in the cause list. Therefore, the appellant shall serve the notice on the engaged counsel of the respondent number 5 and 6. Let this matter be listed after 4 weeks.
Obliged, Lord.
No, today he has not come. Therefore, your lordship will fix it tomorrow, my lord. Because my decree is of my lord 2009, my lord.
Day after tomorrow.
Day-
Otherwise,
Tomorrow,
an
my-
engaged counsel is there. Mr. Goswami is appearing.
Yes, my lord. Today he has not come. Only some typographical error, my lord, in the
Can-
schedule, my lord. Instead of my lord DAG number, it was mentioned as periodic pattern number. That was mistake, my lord. But in the paragraph
Okay,
One
let,
of the-
let him come on. None appears for the applicant petitioner on call. Heard Mr. T.
T.
Islam, learned counsel appearing for respondent number 1.
one,
Respondent number 1, stop. Let this matter be listed again on. Take it in next week.
next week, my lord. I have some difficulty.
Okay.
Your lordship may take it for Wednesday, my lord.
On 16, 17, 18th. Wednesday.
Yes. Well, my name may be shown, my lord, registry may be
The
directed.
the registry is directed to reflect the name of Mr. T. Islam as as the engaged counsel for respondent number 1 in the cause list henceforth.
Okay. And this, matter they are for the respondent. Matter this is an appeal by the plaintiff. Plaintiff's suit was decreed by the trial court and the defendant counterclaim was dismissed.
Counterclaim was dismissed.
Dismissed.
Yes.
On appeal, the decree was modified. The plaintiff's decree was partly modified and the counterclaim was also partly allowed. Very interesting. Lordship,
In
can you have it,
appeal.
my lord?
In appeal.
In appeal. I have
Oh.
come against that. I have framed the substantial question of law, and I'll come to that little later. Lordship, may kindly have a look at page 14 is the relief that I paid in the suit matter. There are two plaintiffs, two sisters are there.
Page 14.
Page 14.
Yes. What was the
The relief number 1 is for declaration that plaintiff number 1 is the owner having right title interest and possession over Schedule A land.
yes.
2 is for declaration that plaintiff number 2 is the owner of and having right title interest over the Schedule B land.
Yes.
Then Roman 3 is important by not for declaration that no road is entitled by the defendants over the suit land A in B. There is slight mistake in the sentence, my lord.
Right of way.
Prayer, yes, madam. Right of way. The defendants are claiming a right of way, so we have basically prayed for a negative relief that there is no road. Now, a counterclaim was filed. The prayer in the counterclaim, lords will find at page 24, madam.
Yes. Yes.
Relief number 1 prayed for by the defendant is declaration that sale deed number 499 and 450 of 1999 registered on 1/3/1999 in the office of Sub-Registrar Dibrugarh
The
is-
sale deed is in your favor.
is in my favor. There are two plaintiffs, there are two sale deeds, my lord, in favor of the plaintiff. So they have prayed that these two sale deeds should be declared as void. And this, when the second part of this prayer, lordship may kindly see, this is very important. Not entitled to any right title interest over the land described therein, or at least to the extent of 13 feet by 286 feet of the land, a part of which is a passage on the northern side of the land described in Schedule A and B. Then subsequent reliefs are more or less consequential. Cancellation of names of plaintiffs from the relevant Jamabandi, etc. These are not very relevant. Then Roman 4, lordship will kindly see. Declaration that defendants are entitled to use the said 13 feet by 286 feet land as a passage for ingress and egress on their backside land as easementary right out of necessity. So they have claimed over this plot of land. Now, if your lordship considers these two prayers made by the defendant, their prayer is that
Easement right.
on, yes, easement right over a path measuring 13 feet by 286 feet. This path they are claiming in between the land of the defendant and the plaintiff. Now the prayer number 1, if your lordship sees, my lordship, basically is that the defendant is saying that 2 sale deeds on the basis of which the 2 plaintiffs are claiming title are void, are to be declared void. And if not the entire sale deed, at least to the extent of 13 feet by 286 feet of the land, a part of which is a passage on the northern side. So according to them, our sale deed will be void to the extent of 13 feet by 26 feet in length. This is their prayer. Now, lordship may kindly see what is the judgment of the trial court.
Page.
Start from page 31, my lord. I am taking your lordship to the operative part, which your lordship will find. My lord, page 39, lordship may kindly see first.
Counterclaim was dismissed.
My lord. Page 39, paragraph 25.
Yes.
In the result, the suit is decreed on contest with cost. The counterclaim is dismissed. The right title and interest of plaintiff number 1 over schedule A land and of plaintiff number 2 over schedule B land are declared. Defendants are not entitled to any road over the suit land. The defendants are directed not to enter into the suit land and to disturb the peaceful possession of the suit land by the plaintiffs. My lord, the reason for passing this type of decree is, my lord, if your lordship kindly turns to page 38.
Yes.
Page 38 is the discussion on issue number Roman 7, whether defendants have easementary right over the passage of 13 feet by 286 feet. My lord, I possibly need not need the entire paragraph. From the bottom, if your lordship kindly comes to about 6th line from bottom, my lord. Towards the end, lordship will find there's a word concept, the concept.
Yes.
The concept of easement of necessity also does not hold good in the present case. DW1 has stated in her cross-examination that in the western side of the land purchased by her father, there is a municipal road known as Good Street. DW3 so-and-so has also stated in his cross-examination that land of Dr. So-and-so is adjacent to the Good Street. Since the defendant's land is connected to a municipal road, there is no absolute necessity for the defendants to claim easementary rights on that ground. It was held in the case of C. So-and-so that the existence of an alternative pathway, however inconvenient, will defeat the claim of easement of necessity. The necessity must be absolute and must be subsisting at the time when the plaintiff claims right of way by easement. It appears from the above discussion that defendants have no easementary right over the passage of 13 feet by 286 feet. This issue is decided against the defendants. So based on this issue, and also as regards title, my lord, title has been decided, as your lordship has seen, my lord, 2 sale deeds have been found to be valid. This was the decree passed by the trial court.
What happened in?
Then appeal was taken by the defendants. Appellate court has decided, my lord, in a very peculiar way under order 41 rule 33. I'll take your lordship to first the operative part of the order at page 67, my lord.
Yes.
17%. If your lordship kindly excuses me, my lord, I'll draw your lordship attention to page 63, paragraph 15 onwards, my lord. This will make the position clear.
Yes.
page
No, what,
63.
what trial court has decided,
My lord,
and the appellate court has decided?
My lord, appellate court say that if you don't spot verification taken. My lord, the appellate court appointed a commission to find out the exact location of the land.
Okay,
Then when
there was a prayer.
yes,
Okay,
then when the report was submitted, it was found that both the parties are actually in possession of land in excess of their actual land.
no, what was the reference made?
Reference was to make a spot verification and report. Now, report has come saying that both the parties are actually occupying land in excess of their actual land. Lordship may kindly see. I'll take your lordship to the exact paragraph. Page 64, my lord, para 17.
Yes,
Lordship has got my lord, page 64,
yes.
para 17. Apart from the above, the learned trial court appointed, Sri so a practicing lawyer of Dibrugarh Bar Association as advocate commissioner to make a spot verification of the disputed site. Learned advocate commissioner with the assistance of the concerned revenue office and Lat Mandal made a spot verification of the site. His report is marked as Exhibit 19. From his report, it appeared that the plaintiffs are in possession of the excess land measuring 14.65 leches. And similarly, the defendants are also having excess land measuring 5.06 leches in their possession. Although the parties cross-examined the witnesses on other grounds, neither party challenged his report on the excess land found by him in their respective possession. Thus, it is clear that the fact pertaining to possession of the parties over the excess land is an admitted fact. From what has been stated above, it has come into light that there existed a road path for egress and egress for the common public to the court and several offices, but the learned trial court did not consider those aspects and decided the issue number 5 and 7 erroneously. The learned trial court, without going through the entire material evidence and documents, very mechanically passed through and wrongly decided that so-and-so had no passage measuring 13 feet by 286 feet. He has also wrongly decided that the appellant's defendants have no right over the path. Accordingly, the point number 1 is decided in favor of the appellant defendants. So far as the decision of the other issues are concerned, the learned counsel for the parties did not raise any objection. As such, I am not entering into the detail. That being the position, in view of the decision on point number 1, I am of the considered view to hold that the impugned judgment and decree is not sustainable in law. As such, the same is hereby set aside. Before conclusion, I deem it proper to put on record that the court of law is established to bring peace in the society by mitigating the disputes arising in between the parties. The litigants used to come to the court for resolving the disputes in accordance with law. Law may not take into account on all spheres of public life. As such, the principle of natural justice, good conscience, equity, fair play, etc. also play an important role in deciding the rights of the parties. In the case in hand, from what has been discussed above, it has come into light that both the parties are having their right title interest over their respective lands purchased by them. And this is very important. So plaintiff's land cannot be touched. Neither party has any absolute right over the excess land found in their possession. The land was used by the common public to attend the court and other offices. As of now, the offices are shifted to their respective places. Only the parties to the suit are using that plot of excess land, and as such, the present dispute in between the parties must be required to be sorted out. Order 41, Rule 33 CPC casts a duty on the court to dispose of the dispute finally, although such point or points may not be taken up in the memorandum of appeal or cross-objection. A broad and dynamic interpretation of the provisions reflect that the appellate court must strive to decide the disputes in their proper perspective so that the parties will not be dragged into the court. Considering the complex facts and circumstances, I am of the considered view to pass the following order. A. Both the parties respectively, so and so and so and so are plaintiffs, I'm sorry, both the plaintiffs are hereby declared as owners and title holders of the suit land A and B respectively.
That is affirm the trial court's order.
Exactly, madam. Then B. Without prejudice to the rights of the true owners, both the parties are entitled to use 13 feet by 284 feet road path included in this excess land found in their respective possession. If 13 feet by 286 feet covers an area beyond the land measuring 1 katha, that is 14.65 plus 5.06 lesser, the size of the road or path may be reduced so that the land for the path road shall not exist over a plot of land more than 1 katha. To avoid complexities, the parties in cooperation with each other, or if no cooperation is arrived at, the appellants with the assistance of the concerned circle office shall do the needful to identify the path of 286 feet by 10 feet with the excess land noted therein above. The respondent plaintiffs are hereby restrained permanently from causing any interference in respect of the use and enjoyment of the path that may be identified properly in the manner stated herein below. In the interest of justice, it is directed that parties shall bear their respective costs, prepare a decree accordingly, dispose of the appeal on contest. This will be.
What is your submission?
Otherwise, I have got only 2 submissions and 2 substantial questions of law which I have raised. The learned First Appellate Court has found on the basis of the report of the Advocate Commission that both the parties are in excess of their land, position of land in excess of their land. And measuring, that is measuring 14.65 and 5.06 lesser. But what the learned First Appellate Court has done is, has presumed
That it
that
falls within
this
the.
excess land is in between their lands, number one. This presumption cannot be made because
There was no material.
no, my lord. My lord, my excess land may be on the other side of the land. Even the defendant's excess land may be either on the west or east or we do not know, my lord.
Yes.
And secondly, my lord, what the learned trial court or the civil court was required to decide has now been handed over to the circle office and to the parties. You identify. They cannot identify. Court is to identify. With the help of circle officer, court will do with that. So I have framed these 2 substantial questions of law, my lord. One is whether the findings of the learned appellate court below on issue number 5 and 7 are perverse, being based on assumptions and conjectures inasmuch as the excess land of 14.65 lecha and 5.06 lecha found to be in possession of the plaintiffs and the defendant respectively are not identified. Secondly, my lord, whether the learned court of appeal below was justified in conferring on the defendant and the circle office the authority to adjudicate upon the identity of path measuring 286 by 10 feet. These are the 2 substantial questions of law according to me are involved, my lord. Because excess land is there. My lord, I have from the same owner, both the parties have purchased the land, my lord. We have purchased first in point of time. Defendants have purchased subsequently. Now excess land is there, but then it has to be identified as to on which side of the land of both the parties that excess land is lying. Otherwise, my lord, so far as the claim, this has been done by the First Appellate Court with, my lord, all the philosophy of, my lord, justice should be done by the court, etc. What the learned court has presumed is that excess land is in between the 2 plots of land. And this has been done for the purpose of doing justice, that the defendants actually are saying that they have a easement of necessity, right of easement of necessity on that land between the 2 parties. And the trial court has come to a clear finding that the easement of necessity will not arise in this case because they already have that good street road. If your lordship has visited my lord Dibrugarh Court, my lord,
where this road is, in which side of the court?
Dibrugarh, my lord, I have prepared a small sketch map sort of. This is only a sketch with pencil. Lordship will see on the western side is the Good Street Road. Lordship has seen, my lord. Western side,
Yes.
Good Street Road is this one. Now, the Bakchi's property is the plaintiff, my lord, and Hakim's property is the defendant. Now, both of them can easily come out with to this Good Street Road, which is a huge road, my lord. So the claim of my lord, this easementary right in between the two land is basically, I have seen somewhere, my lord, for the purpose of the tenant which are who are residing on the backside of their land. That is not the purpose of the matter of the easement of necessity.
Yes. You have any objection?
And this is no objection, my lord.
We
Maybe
can-
admitted.
You
This
could have.
requires adjudication, my lord. Lordship will have to hear on merit, let the records be called for.
Heard Mr. B. Majumdar. Learned Senior Counsel assisted by Mr.
G.R. Datta.
G.R. Datta, Learned Counsel for the appellant. Also at Mr.
I Rafiq.
I. Rafiq, Learned Counsel for all the respondents.
All the rest.
All the respondents. I have perused the memo of appeal. And considered the submissions made by learned counsel for the parties. On perusal of the memo of appeal, as well as considering the submissions of the parties, this court is of considered opinion that following substantial question of law is, no, this court is considered opinion that this appeal involves substantial question of law which needs to be adjudicated in this appeal. Accordingly, following substantial question of law is hereby formulated. Only one. Whether the findings of the learned appellate court within inverted comma. No, learned first appellate court on issue number 5 and 7 are for issue number, what are issue number 5 and 7?
One is matter in respect of this easementary right.
Appellate court also framed points for
Same.
determination. Issue number
Five is in respect of the
5 and 7 are perverse and based on assumptions and conjectures. In as much as the excess land of 14.65 lecha and 5.06 lecha found to be in possession of plaintiff and defendant respectively are not identified. Inverted comma close. This appeal is admitted for hearing. Call for the case record of the trial court as well as the first appellate court. Let this matter be listed again after 4 weeks on receipt of the records requisition.
there is an IA for stay.
Stay.
The road is being used by both the parties.
Let them, both of you are using now.
Yes, my lord.
No, road is not being used.
No, no.
My
We are
lordship-
using the road, my lord.
No, my lordship may see the direction.
Let the record come, then we will consider whether interim relief is necessary or not.
I don't, interim relief will lordship will consider if the appeal is admitted, interim relief is not granted, then execution will take place because lordship will kindly see the nature of decree pass.
No,
Now it will go to
execution
the
is,
circle office. It will, entire thing will go to the circle office for identification, etc.
okay, that
Your
portion, is-
lordship is in season of the matter, lordship has admitted now,
That-
the
that
circle
can
officer
be-
will start the
that portion
identification.
has to be stayed.
Yes, ma'am.
But the use of easementary right may continue.
Well,
Yes, sir.
easementary right, they have prayed, the court has not granted, trial court has refused. Trial court has refused, saying that you have already the good split.
What
road is-
appellate court has said?
Appellate court has said that now it will be identified, then you will get.
Okay,
So unless it is, now lordship has said that identification is not right by the learned first appellate court.
My lord, the road is using by our tenant, my lord, and also by them also.
Hello, we
If
are
it
not
is
concerned-
stopped, my
we are
lord, they
concerned
cannot
with the
go out.
Now, on record, the court has asked for identification.
that portion will be stayed.
That portion may be strict.
My lordship is, otherwise your lordship has
Road cannot be strict.
admitted the appeal, and I'm just submitting. Lordship has admitted the appeal on the ground that identification has to be done. Now, if identification is not done, and then again the decree is not stayed, then they will identify, they will do these in execution of the decree passed by the first appellate court.
Which one is the IA? There is delay also.
No,
Delay has been condoned.
delay has been condoned long back. Numbers are there.
Heard Mr. D. Mujumdar, learned senior counsel, assisted by Mr. S. What is the name? G.R. Dr. Learned counsel for the applicant. Also heard Mr.
Arif.
R. Rafiq, learned counsel for the respondent. This interlocutory application has been filed by the applicant under, where is that I? This
I
is
is there. IA number.
are with I.
What I can do, they can put it, propose it to us. They ask for your half of it, sir. Company program, 377 million.
I number 2111.
211, condemnation of
Order for, order 41 rule 5 of the Code of Civil Procedure, 1908 for stay of
condemnation.
whether execution case has been filed,
I'm praying for stay of the judgment in decree, ma'am.
but there is no provision for stay of judgment and decree.
Yes, execution. Unless your lordship has admitted the appeal, lordship is
No.
satisfied.
No, my query is
Fine.
whether judgment and decree can be stayed.
No,
in
execution has to be
a,
stayed.
execution has to be,
They will.
when they have not filed a,
No, they have not filed. If your lordship is satisfied that there is sufficient question of law is involved, appeal has been admitted. It is normally when this is the practice followed that.
no, you make me understand what is to be stayed.
State, lordship may kindly see page 67. What I'm
Execution
saying-
has to be stayed,
Execution has to be, that is correct.
but no execution case has yet been
They will
filed.
file it tomorrow, and then again I'll have to come out with another application. And this is not the practice for that. If the appeal is admitted, stay is not granted only because when they have not filed the execution. It has to be stayed because if the lordship is satisfied that the decree is decree.
No, I am not,
I understand. Your execution
because
is-
this is an interim relief.
I know.
Order 41 rule 5, during the pendency of the appeal,
Appeal.
this is a interim relief.
True, man.
Interim relief is to be granted if there is some urgency. Urgency would be reflected if there is a pending execution where the decree may be executed at any time. But now none of the parties have filed any execution.
I don't,
This-
in my humble understanding is if the appeal is admitted and decree is not stayed, only on the execution is not stayed on the ground that they have not filed the execution case. Tomorrow they will file, then I'll come again This will only increase the, my lord, litigations. I think some are not difficult. But the nature of the decree is such it will go the, your lordship is in season of the matter as to whether identification is to be done or not, whether the decree passed by the first appeal court is correct or not. Your lordship has admitted the appeal. Your lordship will decide today or tomorrow when the matter is heard. Side by side, they will start a proceeding of identification.
You can come at any time you can pray for execution, stay
I
of
can pray.
execution.
Yes, man, I can pray. No
But
difficulty.
now there is no execution proceeding is pending.
My lord, in they, if the appeal, I leave it to your lordship, my lord.
No stay now, unless there is an execution file.
Then lordship may kindly indicate that, my lord,
Yes.
that I am not staying because no execution has been filed.
Has prayed for. Now one more query.
Right.
Is there any provision for stay of the operation of judgment?
No, it's for execution. Order 41.5 is.
But that is the language which you have used in your application.
I have not seen it. No.
In prayer portion, you have mentioned.
Well,
execution.
I just, let me just.
Yeah, for staying the execution of the impugned judgment and decree dated 4/8/2018 passed by the learned First Appellate Court in title appeal number 10/2014. Stop. The applicant herein has filed a connected regular second appeal, which has been registered as RSA 126/2024. Stop. I have heard learned counsel for both the parties. Senior counsel for the petitioner has, applicant has submitted that presently no execution case has been pending. The counsel for respondent has also submitted that no execution case has yet been filed by any of the parties. Stop. In view of above, this, in view of above, let the notice be issued to the opposite parties as Mr. Rafiq, your initials, Mr. R. Islam, Mr. I. Rafiq has already appeared for opposite parties. No formal notice need to be issued. Stop. This court is of considered opinion that as presently no execution case has been filed.
I'll, if your lordship permits, I'll just interrupt your lordship for a moment. My lord, the nature of the order. So first of all, my lord, the possibility application is correct. We have prayed for stay of execution of the impugned judgment and decree.
In the prayer.
In the prayer, yes.
In the cause title you have mentioned.
That's a mistake possibly, my lord. Yes, in the prayer, prayer is for a stay of execution. And secondly, my lord, lordship may just once have again.
Nature of the order is such that
Nature of the order is such that we'll have to do it. My lord, lordship may kindly see. Now, the parties in cooperation with each other, or if no cooperation is arrived at, the appellants with the assistance of the concerned circle office shall do the needful. So they will go ahead without filing any execution case. The lordship may kindly see the nature of the order passed. To avoid complexities, the parties in cooperation with each other, or if no cooperation is arrived at, the appellants with the assistance of the concerned circle office.
But granting stay of the first appellate order would also mean staying the use of that easementary rights which they are claiming. That would automatically be stayed. This portion requires some stay. I have understood. But if we grant an blank, or we can mention it.
My lord, here, if your lordship permits me, I'll just point out one more thing. The prayer of the plaintiff, sorry, defendant in the counterclaim of easement right is over the land on which the plaintiffs have paid for declaration of title. Am I clear? They have their first prayer in the counterclaim, they say to the extent of that 13 feet by 287, the decree should be declared void.
No. Wow. Yes. There are some aspects in the judgment of the first appellate court.
Yeah.
One, the executive magistrate is directed. Who is directed? Circle officer. Circle officer. There, some stay may be required.
No, but I'm on a slightly different issue now.
No, let me put my query.
I'm sorry.
Other aspect is they have been given easementary rights. Appellate court has recognized their easementary right.
Recognized, yes.
Recognized. If so that they will continue.
No, well, recognized. Now it has to be identified. Then thereafter they will continue. Not now. It is not the finding of the trial court or the first appellate court that they are using it already. They said that we want a declaration from the court that this should be declared as a easement of necessity. This declaration has been given by the first appellate court. Now, first appellate court said you identify it mutually to avoid complexities, parties in cooperation with each other, or if no cooperation is arrived at, the appellants with the assistance of the concerned circle office shall do the needful to identify the path. So now, after it is identified, then if there is no stay of the judgment, then it will be used. This is the position, my lord, in my humble understanding.
Presently, land has not been identified.
No.
But they are using it.
No, but there, Wood Street Road, they are using. This is the finding of the court below. This finding has not been.
But that disputed land is also being used.
Yes, my lord. They have claimed.
Therefore, no, therefore you are before the court. You approach the trial court only to restrain them. That
Yes.
you sought a negative declaration.
Yes.
That they don't have any such right.
Yes.
Trial court gave you that relief.
Right.
The appellate court reversed it.
Right.
Reversed it meaning that they have such right.
My lord, here there is one catch is there. That's why I wanted to submit that. Their prayer was that 13 feet by 286, a strip of land from your cell deed should be taken out for my use as easement right. This was their claim in the counterclaim. My lord. Now, first appellate court has come to a clear-cut finding that plaintiffs are entitled to declaration of right title over Schedule A and B land. This is the judgment of the first appellate court also. Now, if my land, the declaration is made that I have got right over my land, and the plaintiff's prayer is that that easement right should be on my land, then there is a conflict of matter of the finding of the first appellate court itself. On the one hand, it says that excess land is here. On the other hand, it says that you have got right over Schedule A and B
And
land.
by staying the first appellate court's order would also mean staying that to that extent also where you have been given benefit. Your right have been
No,
recognized.
my right has been declared by the trial court also. That will remain, even if the first appellate court judgment is stayed. And my right over Schedule A and B have been declared by the trial court. It is the first appellate court which has come to such a finding that there is a contradictory stand that on the one hand, you have got your right over Schedule A and B land, and on the other, a strip of land from your suit land will go now to be used as easement right. This is my submission subject to your lordship consideration. There is a conflict in the judgment of the first appellate court.
Yes.
Because trial court's finding about my right over Schedule A and B, over which the defendant has claimed a portion, has been confirmed by the first appellate. on the one hand. And on the other, it says, no, there will be a strip of path.
What would be the impact of stay?
Impact of stay will be this, particularly this part which requires that there will be, my submission is, if, hypothetically thinking, if otherwise they are using and plaintiff is also not objecting, this will go on, this is not a part of the judgment. Judgment says that in the operative part that you will have to take steps to the extent of cooperating with each other. And if there is no cooperation, that the appellants with the assistance of the concerned circle office shall do the needful to identify the path. So if there is no stay, they can go ahead with this process if there is no cooperation. Then again, I'll have to come. That is why I'm saying,
What was the line? No execution case has been filed. Stop.
because this
If we can stay the capital B of the order portion. You look at B.
Because, my lord, the order 41 rule 5 says, my lord, an appeal shall not operate as a stay of the proceedings under a decree. So if this part is not staying, then they will start a proceeding under this decree. This is the difficulty, my lord. On the one hand,
Regarding stay of B, you have any objection?
Regarding
That B portion,
B portion, yeah.
because your relief is under C,
Yes, ma'am.
not restraining you from using.
Yes,
So if B has to be stayed.
yes.
However, considering the nature of order passed by the first appellate court at paragraph B within bracket B, where the concerned circle officer was directed to identify the path of 286 feet into 13 feet with the excess land indicated in the impugn judgment, is hereby stayed till the pendency of the connected regular second appeal. Then interlocutory application, we can dispose it of. That B portion is.
I'll leave it to your question.
With above observation, this interlocutory application is disposed of. We have stated that circle officer portion.
Yes. All as agree.
Deep reply.
Please, your lordship, pass over the matter for the time being.
Lordship, my prayer is that lordship may adjourn the matter because I have to go through some more money. So there is a concurrent finding.
Heard Mr. S. Nath. Learned counsel for the appellant also admits what is
SS Bora.
SS Bora appearing for this respondent number 2, respondent number 1. Learned counsel for the appellant has prayed for an adjournment on the ground that he has to go through, he has to go through certain documents before making his submissions. The prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Well, this is a concurrent finding, my lord. The appellant, my lord, he was originally defended in the title suit. And the title suit was decreed in favor of the plaintiff respondent. So against that, the first appeal was preferred, and that was, my lord, dismissed, upholding the decision of the trial court. According to the second-
You were the defendant.
My lord.
In the title suit, you were the plaintiff. Plaintiff. Your
I am in the title suit, I am the defendant.
defendant. Suit was dismissed.
This was decreed.
Decreed. You preferred an appeal. Appeal was dismissed. Okay. Now, what are the substantial questions?
Substantial question I frame at page 8, my lord. There are the two substantial questions. Because the land, my lord, that was belongs to the plaintiff, this is defendant appellant. That was, my lord, he's inherited by dint of a, my lord, gift. So, but subsequently that land was, initially that was a, my lord, in accionial land, my lord, and that was converted to Miyadi Patta land by depositing the, my lord, the premium. And accordingly, land was mutated in my name. But subsequently, my lord, what happened? The respondent number 1 and 2, they surreptitiously, my lord, mutated their name in that portion of land, showing that they are also entitled, this is a land of inherited from my father. So that subsequently, my lord, their name was deleted, but that was not considered. And in spite of the fact that the one of the portion of the land, 1 kata 11 lesa, that was purchased by the respondent number 1 from me, admitting that the land is belong to me and owner. That everything was not considered. So there was a two substantive question, my lord, I framed. The number A, my lord. Lordship got it, my lord, in page 8, my lord. Whether the purchasing a portion of a land from the appellant, admitting the appellant as the absolute owner of the entire land, can a respondent number 1, plaintiff, pro forma defendant, again can claim the ownership over the remaining land by taking the plea of my lord, ancestral property. The second one, my lord.
No, what is the bar? Where is which bar?
Bar was because, my lord, the land, my lord, the person.
Stop it.
4 kata, 4 lesa, 4 biga, 4 kata.
No, what is this substantial question of law? Suppose I say you are the owner.
Yes, my lord.
Only oral submission or what? How he admitted?
It is by deed of a, my lord, the registered deed, my lord. That land was purchased by the registered deed. And from the same land, over which now he claiming as 1/3 of his share, the remaining over. This is the case, my lord. And they admitted the land, my lord, originally that was from one Safi, he donated me. And after his death, my lord, that land was, I am being the possessor. Initially, that land was, my lord, 5 biga 15 lesa. But the government, my lord, has given, my lord, on payment of premium.
What was the scheduled land? And the area of the schedule?
That is, my lord,
that is, my lord.
Lordship will get, my lord, at 69 page, my lord.
One biga 3 katha.
Yes.
5 lecture.
This is 1/3 share. 1/3 share, defined share being the 1 biga 3 katha 5 lesa from the joint land property measuring 4 biga 4 katha 15 lesa and the land measuring 1 katha 11 lesa. That is his purchase, my lord. I have not on that. Whatever is purchased, that is gone to him as per the by dint of a sale deed, registered sale deed. But the remaining land, he and the respondent number 1 and 2, earlier his plaintiff number 1 and the performer number 2, they claim that this land is an ancestral property, that they should be having the equal shares among the three brothers, 1/3. So that was the case, Malad. But case is this, Malad, the land originally that was, I have acquired by dint of a gift. And after getting the property on gift, I, Malad, they applied for the, Malad, Miyadi Patta, and the government being satisfied by possession since long has given the mutation, converted the land on depositing the premium, 18,000 something. And subsequently, my land was mutated in my name. And what they did, subsequently, in subsequently, they are mutated in along with me in the same land. And that mutation was later on cancelled by the SDC. But that fact was not considered at the time of the deciding this suit. So substantial question, that is why this is a very.
No, then we will go into questions of facts.
Yes, ma'am.
These are questions of facts, man.
Question of facts, the substantial question will not only come to the question of facts, the law also will cover. Question of facts will be decided in the first appeal. The second appeal, this is a substantial question, it is a law and facts in both side by side. Here the law is this, if you once you are admitted, this land belongs to me and you have purchased the portion of the land, and subsequently what got you right to say this land is an ancestral property, and denying all the facts that whatever it is.
Where he has admitted.
My lord?
Where he has admitted that.
My lord, this in the this is the exhibited document by the plaintiff in his the title suit, and the findings of the issue decided while the decision was decided. My lord, lordship will come. The issues, my lord. In the title suit, my lord, 4 or 5 issues were taken jointly from 5 to. Here, my issues were framed at page 44 in lordship gate.
Before the trial court.
Before the trial court judgment, my lord. Altogether, 7 issues were framed. Page 44. It is started whether this suit is maintainable. It is then the issue, vital issue is coming from page issue number 4. That is whether this suit land was originally annual patta land and later on converted to PP land in manner of plaintiff in the name of the plaintiff, defendant and the performer defendant. And the while the matter was taken by the trial court, the all 4 issues, it will take a lordship at page 49, my lord, where all remaining 4, 5, and 6 and 7 issues were taken together. And lordship straight will come to page 51. The first para. Evidence on affidavit of examination in chief of the defendant, witness DW1, Mohammad Nur Hussain, stated that the total land measuring 5 bigha 15 lessers was under annual patta land in the name of the Muhammad Saki. Actually, that should be Safi, my lord. Exhibit 5 is the photocopy of the Jamabandi in the name of one Muhammad Safki, defendant, as DW1 has reiterated that Muhammad Safi had handed over the possession of the entire land during his lifetime, and that after the death of Muhammad Safi, defendant deposited Miyadi premium of rupees 18,563 for conversion of the said annual patta land to Miyadi patta land. Accordingly, annual Additional Deputy Commissioner Revenue, Sunitpur at Tezpur, had passed in order SRS 8/such dated 24/12/2004 for conversion of the land and entered the land measuring 4 bigha 4 katha 15 lessers, not only 5 bigha, my lord, under the PP number such 160 dark number 600 in village Gotlong Moja Bhairatpur such. Defendant Exhibit A is the original case record of order SSS. This is, my lord. There's a record I have, my lord, proof by which, my lord, the land has been mutated, well, converted to Miyadi patta land. And again, your lordship will come Straightway to my lord, page 54.
You are Muhammad Safi.
I am new, my lord.
Nur Islam.
Safi is a reference number 1, my lord. He was the original plaintiff in this suit.
No, now you are saying that these 5 bigha 15 lechas land was originally annual patta land.
Malo.
Annual patta land. Then you paid the premium.
No, I paid my entire land and premium has been paid by me, my lord.
That is my question. You paid the premium.
Premium.
On your payment, the land was mutated in your name. Patta was granted to you.
In my.
Out of that land, the plaintiff was given 1/3. Is it the case?
No, my lord, this is the case, but yes, my lord. The remaining 1/3, my lord. This is earlier, my lord, the 1 kata 11 lesa, the respondent number 1 is purchased from me after getting mutated the land in my name, being a patta land.
Let me understand.
After selling of that
Out of these 5 bigha 15 lechas land,
4 bigha, 4 kata, 15 lesa was in my name, my lord. Entire land was not given.
yes, 4 bigha 4 kota 15
15
lecha.
lesa was Miyadi patta converted to Miyadi patta in my name.
Yes.
Out of which, my lord, 1 kata 11 lesa, my lord, the respondent number 1 is purchased after getting my lord mutated in my name. Subsequently, again, my lord, they entered their name in the rest amount of the land. Now they are saying this land is a.
On what basis?
My lord, nothing, my lord. The only basis of the mutation. Initial mutation in their name, the subsequently that mutation was cancelled. But the trial court, my lord, did not consider that fact. They're saying that no, this is the ancestral land as the their entire land has been mutated in the 3 names.
Okay, how?
My lord.
What is your case?
My lord, some contradictory submissions were made, my lord. Actually, my lord, initially in the annual patta, all 3 names were there, my lord.
What did you say?
In the annual patta.
Nur Islam?
Yes, my lord. The plaintiff, performer, defendant, and defendant.
What is your name?
My name is Yusuf Ali, my lord.
Yusuf Ali.
Yes, my lord. That's Yusuf Ali.
And Nur Islam is your brother?
All are mother. All 3 are brothers, my lord. Defendant and performer, defendant, my lord.
Yusuf Ali is not contesting the case, my lord.
Plaintiff.
He is the performer respondent.
Yusuf Ali is the plaintiff.
No, Yusuf Ali was not the plaintiff. Initially, plaintiff was like Yusuf Ali.
No,
Plaintiff is Yusuf Ali.
Yusuf Ali, my lord. My lord, there is a confusion, my lord. In the annual patta, my lord, all 3 names were there, my lord. When premium was paid by the defendant, my lord.
The total land was 5 bighas 15 lecha.
Total land, my lord. In the annual patta, all 3 names were there initially, my lord.
Okay. All 3 were in possession.
My lord. All 3 were in possession, and on their behalf, my lord, the defendant number 1, my lord, he has paid the premium, and accordingly, the land was made periodic patta in the names of 3 of them, my lord.
But his claim is that it was.
No. His claim is that, my lord, your lordship, his claim is that, my lord, he got the entire plot of land by way of a gift, my lord. But there is no gift deed as such, my lord. Your lordship may come to directly page 61, my lord. That will make the entire thing clear, my lord.
No, at least facts.
Yeah, facts, my lord. These are facts, my lord.
Yes.
He said that, my lord, the court has held that, my lord, there is no gift deed, my lord, he has submitted, my lord. So he cannot claim the entire land is given to him, my lord. That is gone, my lord. Now his claim is that, my lord, since he has paid the entire premium, my lord, entire land should goes to him. The court has held that, my lord, in the annual patta, all 3 names were there on all their behalf, my lord. He has paid the premium, so all 3 names were there while making the periodic patta, my lord. Now from that the portion of defendant, my lord, 1 bigha 11 lecha, he proposed to sell to the plaintiff, my lord. So that doesn't mean that, my lord, I am admitting.
Who is the plaintiff?
Yusuf Ali, my lord.
That is his brother only.
Brother, my lord. So now, my lord, that doesn't.
Brother's name was there along with the appellant's name in the.
Yes, annual patta.
Annual patta.
Annual patta. Annual patta, and also in the periodic patta after
Periodic
conversion.
patta also, his brother's name was there.
Yes.
Then, And then periodic patta was issued in respect of 4 bighas, 4 kota, 15 letters.
Yes, in the name of three of them,
3 of them.
three of them.
Out of which, again, how much land was sold to Yusuf Ali?
One bigha, 11, one kata, 11 letter was sold.
Who sold it?
The defendant sold to the plaintiff, my lord.
Now appellant, my lord.
Now appellant, my lord. Defendants,
But he was himself the owner. What was the necessity of
no,
selling?
my lord. His portion of land, my lord, out of that portion, my lord, one bigha, 1 kata 11 letters has been sold, my lord.
Okay.
Out of his share, my lord. There are three shares, my lord.
1/3 share.
My lord, shares I have in the schedule, my lord.
Okay, okay. From his share.
From his share, my lord, he has sold 1 kata 11 letters of land.
Okay. Thereafter, you have to tell me the story.
My lord. My lord.
So that at least facts are clear.
Yes, my lord. From the entire, my lord, land of 4 bigha, 4 kata, 15 letters, my lord. There are three shares of three brothers, my lord. Out of which, my lord, defendant, this present appellant, my lord, has sold out of his share 1 kata 11 letters.
Okay.
Huh? From his share, my lord.
Where from, my lord?
My lord, that doesn't mean that I am admitting ownership of the entire property.
This is not substantially any document, my lord, from my side.
No, I am not on.
It is not speaking
Not on
like that.
disputing. You have to first narrate what happened before the trial court.
My lord.
What happened
Now,
before the
since
first appellate court.
my lord.
Then only we can find out whether
My lord.
substantial question of law. Because
Hence
he is claiming that the respondent has admitted the appellant to be the absolute owner.
Where, my lord? Which page, my lord?
The substantial question of
My
law
lord.
which he is proposing
My lord.
that once the respondent has admitted the appellant
My
to
lord,
be,
now he is projecting as if, my lord, I have purchased from my lord, I have purchased share of this defendant, my lord.
no, my
That doesn't
query,
mean that, my lord, I am admitting
my query
his
is-
ownership over
my
the
query
entire
is
property, my lord.
on what basis you are saying that he
Because
has
already
admitted?
I am entitled to 1/3 share of that portion of land, my lord. Out of above that, my lord, I have purchased 1 kata 11 letters from the share of this defendant, my lord. That is my case, my lord. And that is court has held. That
One thing I want to clear, my lord. He is claiming that I have sold 1 kata 11 lesser from my share. Then why they are claiming for the 1/3 of the share again, my lord?
yes, my lord. Because
Remaining land?
I'm also
That should be
entitled to
deducted, my
the
lord, minus of the 1/3. After deducting 1/3, that should have been gone from my share. Then why they are claiming that the total land is 1/3?
No, I
No.
am not on that. My query is, Mr. Mohanta, to you. My query is when you are saying that respondent has admitted that the appellant is the absolute owner of
Yes.
the entire land. Where is that admission? Where he is admitting?
I've never
This
admitted,
is
my
a
lord.
substantial question, my lord, because my lord,
I've never
but
admitted, my lord.
substantial question must have some basis.
yes, my lord, this is a
You
document.
are saying that when he has the appellant, the respondent has admitted the appellant to be an
I've never
absolute owner.
admitted.
My lord,
On what basis you are saying that?
my
he
lord,
has-
on what basis one, my lord? When the my lord mutation of their name, that was when the subsequent surplusly, my lord, that was entered along with me, that was cancelled, my lord. They have not challenged that cancellation. my lord.
That's why I preferred the title suit, my lord. That's
That
fair
was,
is there,
that
my
was
lord.
not cancelled and the title suit, my lord, they not cancelled that mutation also.
Yes, my lord. It's
That was
cancelled, my
not
lord.
cancelled.
It's cancelled
And
in the
second
decree,
thing,
my
my
lord.
lord, the record, whatever I, my lord, we exhibited, that is not saying that this exhibit is not proved, my lord. The entire record, the SR, my lord, I have brought as a exhibit, my lord, in the trial suit, trial court, in the trial suit, my lord. That was admitted by the court also, that this is a, my lord, admitted fact, this is subsequently their name was deleted from the mutation. And the where from, I don't know, my lord, he is saying that the originally, my lord, the annual patta lane, the all names were
That
there.
is the findings of both the courts, my lord.
That is to be on the
Findings
basis
of
of the
the
record, my lord.
Your
Where is the
lordship-
record? Where is that record to show that their name was there along with me?
Your lordship may kindly.
The entire, my lord, the proceeding.
One by one. Yes, yes.
That is my lord, entire proceeding, it is showing the mutation process was at my instance. I have deposited the entire money and land is also in my name, my lord, 4 bigha, 4 kata 14 lessa, out of 5 bigha, 15 lessa. Then where from there, my lord, again, my lord, they have any right to say that that land belongs to them also, my lord?
Yes, my lord.
I have paid the entire amount, the entire process was in my name.
That
And
can
they
be,
are
my
only
lord.
saying that they are in the annual patta, their names are, where from? It is not exhibited any
Your
document. my
lordship
lord.
may kindly come to page 61, my lord. That will make the case clear, my lord.
It is there, he is
Page
submitting.
61 of the
on
trial court judgment, my lord.
not based on any document.
Has your lordship got it? Page 61.
Yes.
Second paragraph, my lord.
Yes.
The third line, on the third line, my lord. On the basis of preponderance of probabilities, it is hereby observed that the suit land was originally mutated in the names of three sons of Muhammad Jainuddin and later was converted to the sole name of the defendant. However, upon consideration,
No. Suit land was mutated in the names of Muhammad Jainuddin, who is your father.
Yes, my lord. Father of all.
Is there any document?
Nothing is there, my lord. That is my case, my lord.
My lord, may I read the later portion, my lord? And later converted to the sole name of the defendant, my lord. However, upon consideration and perusal of the material on record, it is seen that the names of the plaintiffs were cancelled on the basis of an order which states that the suit land was gifted to the defendant by Muhammad Saki. In the instant case, as discussed above, defendant has failed to adduce any evidence in support of his claim that he received the suit land as gift, nor has he adduced evidence to counter Exhibit 4 submitted by the plaintiff, which is the Jamabandi, with respect to the suit land, reflecting names of all the three sons of Muhammad Jainuddin. Further, Exhibit 8, exhibited by the official witness DW5, which is the Chitha, dated for 15/3/2004.
The land originally belonged to your father.
Yes, my lord. Annual Patta land, when it was annual Patta land, my lord.
Jainuddin was in possession.
Yes, my lord. That's the case. Thereafter, in the Chitha, my lord, dated 15/3/2004 with respect to the suit land, comprising 4 bighas, 4 kathas, 15 lechas, when it was Exonia under AP number so and so, all the three sons of Jainuddin, the plaintiffs and the defendants. Considering the surrounding facts and circumstances, hence upon considering balance of probability in view of the lack of evidence with respect to the alleged act of gift of the suit land by Shaki to defendant number 1 and the failure of defendants to adduce evidence to substantiate their claim that
No, it says the W5, which is
So my humble submission, there is no substantial question of law, my lord, as of to be decided, my lord, in the second appeal, my lord. The all are questions of facts, my lord, which he has raised, my lord, and those are decided by the by concurrent finding by both the courts below, my lord.
My lord, lordship, I'll give a little trouble to read again, my lord, whatever he is reading, my lord. In lordship, from page 62, lordship, my lord, which is the Jamabandi in respect of the suit land, reflecting the name of the three sons of Muhammad Jainuddin, my lord. It is not saying that Jainuddin is the original patta, my lord. Three sons. And that was my case, man. I have cancelled their names from the Jamabandi, subsequent order. That I exhibited.
no, but Jamabandi will not give you right.
Yes, my lord. And he is saying, trying to project that the Jainuddin is the Jamabandi original pattern, but no, it is saying the three sons of
So what
Jamabandi.
I have understood that
He's projecting in different way.
trial court has observed in its finding that though the name was cancelled on your application, their mutation was cancelled on the basis that you claim that the land was gifted to you by.
Yes, my lord.
Not only that, my lord, the entire premium and everything that was I have deposited. And entire case was in my name. Money was deposited by me. So my lord, after that, my lord, mutation and patta was given in my name. Subsequently, they entered their name in collision with a one mandal. And that was later on detected and that was deleted. Because they have no rights to say that this is their land because the money was paid by me, everything was on my behalf, in my initiative, then what's right they have? Merely saying that they are aware that
Out
three
of-
sons of the Zainaldin, it is not enough to show the proof that the Zainaldin was the original landholder of that particular land. That is no document to show. Nowhere Lordship will get the name of the Zainaldin, the original patta land.
That is not required, my lord. His basis
So,
is
my lord,
not
this is
there,
a very
my lord.
vital
Because
substantive question of
he is
law.
simply saying
So,
that
that
he.
to be, my lord, decided on merit
No, my
after
lord, no
calling the
question of
records
law is
of the
involved.
Honorable Trial Court, my lord. Otherwise, my lord, it is not possible to decide any issues, my lord.
Straight and clear case, my lord, my lord. He's
He, whatever
claiming, my
is,
lord.
my lord, my learned friend is trying to submit, it is not based on any record. He is trying to project in a different way.
No, my lord, what is
He
this,
is
whatever
trying
is the
now-
findings, my lord, I am showing it
Now
to your
he is
lordship, my
trying to
lord.
say that the original land was the Zainaldin. Where is the name of the Zainaldin? The three sons, father of the Zainaldin. Three sons of Zainaldin, not the original land on the original Zainaldin. And that was when a self-sister entered the names. That is my case.
But the appellant by of a gift deed, my lord, and that is
This is a different.
nowhere to be
When
seen, my
case-
lord, gift.
That was not a document.
And that is
By
the finding,
virtue of a mouth gift was there.
No, my lord,
But,
that cannot be, my lord.
but that on the basis of that lordship, can they decide that the land was a English property of the only three parties? Three parties. And the cancellation of their name, that has been already been done.
That's why I prefer the suit, my lord.
Okay, I'll go through.
So my vital, my lord, submission.
You have
before
any
lordship.
more submissions?
No, my lord.
You also, regarding formulation of substantial question of law. You have any submission? Mr. Mohanta,
My lord,
any more submissions?
this is my substantive question.
Okay,
of
I'll
my lord.
go through the record.
On this, my lord,
Yes,
this
ma'am.
substantive question, my lord, the should may be admitted, this second appeal. And after that, my lord, record may be called for and hearing.
I'll go through the record.
Necessary, my lord, plan for years, my lord.
Mr. This is item number. P. Mohanta, learned counsel for the petitioner. And learned counsel for the appellant. Also, Mr. P. Sundi, learned counsel for the respondent. Let this case appeal be listed for. Listed in orders column on 30 September.
My lord.
30 September. On that day, I will pass orders whether substantial question of law is there or not,
Or my lord, dismiss.
or it should be disposed of. For 30 September for delivery of orders.
Well.
For delivery of orders.
You can fix 5 minutes only for the two items, my lord.
Okay, then we'll take it. After 5 minutes, I'll stop.
My lord.
Or
I will love to stop, my lord.
Or we can do one thing.
My lord.
We can fix it for final disposal at a convenient date. Convenient for you. We will fix it in the second half.
Your lordship, listen to me for 5 minutes. If your lordship thinks that it requires further hearing, I will definitely get it fixed. My lord. Give me only 5 minutes, my lord. 2.5 minutes for both items.
Joke.
There are both the matters, my lord, are connected. And the first item, it's a dispute between landlord
First
and
means CRP 140.
149. The dispute is between landlord and tenant. The first suit was filed by the landlord for eviction of the tenant on two grounds, my lord. First was there was default of payment of rental for the month of May 2009. That was the first allegation. And the second allegation was by the landlady that I need the suit property for the benefit of my unmarried daughter, so and so. That was the claim.
Okay.
After filing the suit and after around 1 year, the entire suit property got gutted down except one small bathroom, Your Honor, which was used as a godown. Though it was originally a bathroom, but it was always used as a godown. that could be saved, my lord, and the stocks that were lying there, that could be saved. After this fire incident, the tenant filed a suit for the renovation and restoration of the suit property.
Okay.
So that is the second suit, my lord. The suit is continuing. Evidences of both parties have already been adduced. And there were certain smaller disputes for which time and again either of the party were approaching this honorable court, including one such incident is that after the fire incident, the landlady submitted an application saying that since the suit property itself has got gutted down, there is no necessity of seeking eviction. So I abandoned the relief of eviction. That was her claim.
Okay.
Thereafter, she came with a petition that I don't want to pursue the suit. It is long back in the year 2011.
You are tenant or
I am the tenant.
tenant?
I am the tenant.
Okay.
So I am the plaintiff in the subsequent suit and defendant in the first suit. Thereafter, she filed another petition saying that I don't want to press my original petition so far withdrawal is concerned, but relief of eviction is not required. But in 2015, she filed an application after a Supreme Court judgment which said that even after the fire incident, the tenancy right remains attached with the land. And after that, they filed an application which was originally rejected. They approached the Honorable High Court. Ultimately, they got the relief. An amendment was carried out. And the prayer for eviction was again inserted. Now, why the present petition? Up to 2018, the evidences were recorded by them. The evidences of both the parties. In 2022, in the meanwhile, the original landlady, she died. And her son was the power of attorney holder who was running the suit all along, despite the fact when she was surviving, my lord, he was the person who was continuing with the suit. In 2022, he filed an application in both the suit. So far his own suit is concerned, he said that we have sold the suit property in the year 2016 when the matter
Who
was
filed, you or the landlord?
landlady,
Okay.
the subsequent substituted legal heirs,
Okay.
who was also carrying the suit as an attorney holder. But after death of his mother, he became one of the plaintiffs. And he informed to the shock and surprise of everyone that we have sold the suit property in 2016. And one of the witnesses who had adduced evidence on behalf of the plaintiff, he had purchased it. And they submitted a sale, saying that since the suit property has been sold out, I don't want to pursue my suit. And the subsequent purchaser may be taken as an assignee, he should carry forward the suit. The subsequent purchaser never filed any application.
Never filed.
Never filed any application. And kindly note the time, my lord. 2016 he has sold, he has approached the lower court in 2022. Similar petition was also filed in my suit, saying that I have already sold, I don't want to remain a defendant, so and so we pleaded as defendant. I objected. I objected on the ground that so far your own suit is concerned, you have all the liberty to abandon, to withdraw. And the cause of action is very specific to you or to your mother. The claim is that I have defaulted in payment of rental for the month of 2009 and that the property is required for the benefit of your sister. These two grounds cannot be taken by the subsequent purchaser. These two cause of action pertains to you only. And as a legal heir, you can carry forward. But if you don't want to continue with the suit, I have nothing to say. So far my suit is concerned, I am the dominus litis. I am the owner or the person who can take any decision. I don't want to continue the suit against the purchaser who has purchased during the pendency of the suit and who was not ignorant about the pendency. He himself is one of the witness adducing evidence in your support. And even the sale did also have a recital that there is a pending suit. So I don't want to substitute him.
Okay.
Both the petitions were allowed. The petitions filed by the plaintiff in his suit and the petition filed in my suit by the defendant.
Against that, yes.
Against that, I have come. There are 2-3 judgments, my lord. This is my submission.
Okay, you show the judgment after the or not now. We'll take it up after we may dispose it off finally
My lord.
today.
Then can you fix it on a date, my lord?
Well,
Post Durga Puja, my lord. 29th October is convenient to me, my lord. If your lordship so pleases, it can be kept part heard.
no, we will not keep our third. Heard Mr. S.K. Singh, Learned Senior Counsel assisted by Ms. A. Ganguly, Learned Counsel for the petitioner. None has appeared. No, it is already proceeding ex parte.
My lord.
Start. Hearing remain inconclusive. Release this matter again after 4 weeks, 2 weeks.
29th October, my lord.
On
Can it-
on 29th October as a part heard matter,
Highly obliged.
both the cases.
Right.
Item 22 for
Amen. Yes,
Lordship, we need 4 weeks time to reconstruct the file, Lordship. It was last listed on, if I'm not wrong, it was last listed on 2012, Lordship. So we have we have lost some.
be louder.
Lordship, we need some time to reconstruct.
You
our-
need time
4
for
weeks time for reconstructing a file.
reconstruction of whose file? Your.
Our
Okay.
Lordship,
Anything
I appear for response number 1, 2, 3, and 4, Lordship.
heard, Mr.
BP Sharma.
B.B. Sharma, Learned Counsel for the appellant. Also heard Mr.
B. Devi, Lordship.
V. Devri, Learned Counsel for respondent number
1 to 4.
1,
1 to 4. 1, 2, 3, and 4.
1 to 4. Learned Counsel for the appellants submitted that the appellant has, Learned Counsel for the appellant has misplaced his brief and he needs some time for reconstruction and tracing the original brief. The prayer is allowed. Let this matter be listed after. This is a very old pending case. After 2 weeks on a date to be fixed by registry.
Obliged, Lordship.
LCR receipt, Lordship. LCR only received.
The
As per office note dated 12/9/2021.
you have to mention code. The office note dated 12/9/2024 shows that you have to take fresh steps on,
Yes, Lordship.
shows that
Yes.
the trial court records, the records of the trial court as well as first appellate court has already been received. It also appears that the notices to respondent number 5, 7, 10, and 11 has returned with endorsement. No, 5, 10, and 11 have returned with endorsement that the addressee expired, return to sender. And notice issued to respondent number 7 has returned with endorsement that addressee out of station, return to sender. In view of the said endorsement, the appellant may take appropriate steps as regards respondent number 5, 10, and 11. And as regards respondent number 7, he shall take fresh steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List this matter again after 4 weeks.
That's
May I please your lordship? Madam, this appeal was admitted long back on 17th September 2010. Lord, and NCR is received. My learned friend is appearing for Respo 1. And so for other respondents?
Other respondents, I don't have instruction.
Huh?
No.
Same family নহয় নেকি?
How many respondents are there?
Altogether, my lord, 6.
3 to 6 to staff of 4 also. 3 to 6 staff of 4.
3 to 6 already struck off, my lord. So for respondent to Dasarat Dosha, because
You are appearing for?
brother
Number 1.
1 and 2 are brothers, my lord.
Heard Mr.
Take it.
P.K. Dekar, learned counsel for the appellant. Also heard Mr.
She Sharma lordship.
C. Sharma, learned counsel for respondent number 1. On perusal of office note dated 12/9/2024, it appears that notice issued to, with regard to notice issued to respondent number 2, the AD card has been received back with the signatures of the respondent number 2 thereon. Stop. Then stop. Here is the same stop. Considering the above, the notice is held to be duly served on respondent number 2. By which order this 3 to 6 has been struck off?
Order, lord.
You have
Ordered at 4/4/11 lordship.
okay. Let this case be listed for
After vacation,
hearing
lordship may fix even date.
on a date to be fixed by registry after Puja vacation.
Deeply obliged.
Obliged lordship.
Items 24 to 32.
May it please your lordship. I have taken the Dusty service and earlier is the post and AD and as usual process. All are respondent, private respondents. Lordship. But after getting the Dusty service, then total private respondents are 22. Then out of them, 11 respondents is expired. So now I have to file a substitution petition.
Now, why these IAs are there?
Yes, Lordship.
This IA or this is LA? These are LAs?
The affidavit is also filed
Okay.
for the service.
How many respondents are there?
22 respondents.
In every
Private
case?
respondent.
In each case?
No, each case is first case is appeal, LA appeal 60 is 4 respondents. And LA appeal 57 is 1 respondents. So LA appeal 30 is the 3 respondents.
Separate order has to be passed. Unless we pass separate order.
So it is the link cases.
No, but as regards service. Okay.
Long pending matter.
68 cases, 8 link cases, 9 link cases.
You are appearing for all the appellants.
Yes,
Appellant is NF Railway, na?
yes.
You have gone through the records. In which case, how many respondents are there? You have notings.
Yes, okay.
Okay. Heard Miss M.S.B. Devi.
Yes, Chakravarti.
Heard Miss S. Chakravarti. Learned counsel for the appellant. also heard Mr.
T.R. Gogoi, Lordship.
T.R. Gogoi appearing for
I am for the collector, different, in
Learned
different
government-
section, different respondent for.
learned government
Lordship, Lordship.
advocate appearing for the deputy
Collector, Lordship.
collector
Lordship.
/ respondent.
Yes, Lordship, I have to file the subdivision separately actually.
Who has expired?
Appeal number 60 is the respond number 1, 2, 3. 3 is already expired, and LA appeal 57 is 1 is also expired.
And 1 and 2,
In which case
LA appeal 60.
60 is respond number 1, 2, 3 expired.
All three have
No,
expired.
4 respondents are there. So 1 is alive. 4 respondent now respond number 4 is alive, and respond number 1, 2, 3 is expired. And LA appeal number.
No, just a minute. And you have taken dusty service in respect of which respondent?
Yes.
You just submitted that you have taken steps for issuance of notice through dusty mode.
Yes.
Dusty service on whom you have taken steps?
NF relay.
No,
By NF relay on behalf of NF.
NF Railway.
Yes.
For which respondent?
All are all cases and all respondents.
And
There are 9 cases, 9 LA appeals.
where is the affidavit?
LA appeal number 60, 57, 30, and 59, 14, 62. And 15, 61, and 58. 58, Lordship, I could not taken the dusty service.
Affidavit, do, sir. You have submitted affidavit.
Yes, I submitted the. Service cases.
Okay, to order number of. Stop. क्या लिखा? Stop.
No, that's clear.
Learned counsel for the appellant has submitted that the appellant was directed by this court by order dated 19/6/2024 for taking steps for service of notice on the respondents by dusty mode, and in pursuant to the directions, the petitioner, the appellant, while taking steps by dusty mode in LA appeal number 60/2014 came to know that respondent number 1, 2, and 4, 3 has not expired.
Yes, we have, I have filed an affidavit and explained and everything.
Affidavit on 14th August.
Yes.
You have the affidavit with you. Copy of affidavit with you.
Affidavit is already.
A copy is there or not with you?
One copy is there.
You go through that copy. Now, in LA appeal number 60, whether respondent number 3 has expired or he is living.
Jantina received this notification. Yes, respondent number 3 is alive.
Alive, okay. Respondent number 1, 2, and 4 have already expired.
Yes.
And respondent number 3, Jantiram Das, has been served the notice through the STIMOD. In LA appeal 57/14, the respondent Srinaram Das has expired. In LA appeal number 30/2012,
Bipin Nath.
respondent number 2 has expired. And respondent number 1 and 3 have received notice through the STIMOD. In LA appeal number 59/2014, respondent number 1 has expired. In LA appeal number 14/2015, respondent Debennath has expired. In LA appeal number 14, how many respondents are there?
One is there.
Only one respondent. Respondent number 1 has expired. In LA appeal number 62/2014, respondent number 3 has expired. And respondent number 1 and 2 were served the copies of the notice. In LA appeal number 15/2014, respondent number 1 has expired. 1 and 2 have expired. In LA appeal number 61/2014, respondent number 2 has expired and notices were duly served on respondent number 1 and 3. In LA appeal number 58/2014, the notices could not be served as the respondent could not be found. Stop. It appears that in this bunch of land acquisition appeal and in this bunch of LA appeals, in some of the cases, some of the appeals, some of the respondents have expired as mentioned here in above. Learned counsel for the appellant has submitted that in respect of the respondents who have expired, the appellant may have to take appropriate steps for substituting the legal heirs of the deceased respondents. The prayer is allowed. The appellant may take necessary steps. Stop. As regards the other respondents to whom the notices were served, it is hereby held that notices are duly served on them. Stop. In respect of LA appeal number 58/2014, the appellant shall take fresh steps for issuance of notice. Through which mode?
After 4 weeks.
No, how you will serve? Again by Dasti mode?
No, this is, address is not found, correct address.
Through registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Let this matter be listed after 4 weeks. The petitioner, the appellant may take necessary steps as discussed herein above within the said time. List accordingly.
So say our name should be reflected in the positive as Zia Assam.
The learned, the name of engaged counsel, government counsel for respondent, the deputy commissioner respondent
Lordship.
in this bunch of LA appeals should be reflected in the cause list by the registry henceforth as government advocate,
Lords.
Assam.
Lords.
Not over.
Mass of blessing.
The whole matter, my lord, second appeal, my lord. There was a delay of 30 days, my lord. There, my lord, in between them, one IA recently passed order, my lord, 57/2020. In that order, your lordship may kindly peruse your lordship last order. As directed to my lord, place the my lord pause my lord name of the respondent. Already that has been my lord placed. IAC 57.
This 57 is for what purpose?
That order was my lord.
No, this 57 is what relief you are seeking.
No, 57 already disposed of. There was a direction from this honorable court to my lord, replace the name of the respondent after my lord, to correct the cost title, etc.
Okay, there.
Thereafter, I have my lord already placed here, but case is still that pending, my lord. This IA for condonation of delay of 30 days. My understand name was also possibly shown there. PP Das, that was order. Dispute between my lord sisters and brother.
Delay has to be condoned.
Yes, only 30 days, my lord. Case is filed in
But,
year
but
14.
who is for the other side?
Yes, my lord.
Who is for the other side?
PP
Mr.
Das, my
PP
lord.
Das.
Yes, my lord. After the death of my brother respondent, my lord, my sister-in-law and my lord niece has been free.
Whether notice are served on
This new party names not same thing. Earlier he has appeared. my lord. Mr. PP Das.
no, but whether he is appearing for
Then I have to send notice, my lord.
yes.
Better I think, my lord, I have to take step.
You can serve notice on Mr. PP Das also if he accepts. If he accepts that I am still continuing,
Yes,
then
madam.
okay. Otherwise, you have to send fresh.
Sending. By 3 days.
So, in alternative, you can serve notice. You can notify the engaged counsel also. Who expired?
Brother, my lord. Respondent brother,
name,
sole
name?
respondent.
Name?
His name was my lord Subarneswar Thakuria.
And now who are substituted?
Wife and daughter.
Daughter and wife. Okay. So you issue fresh notice.
Yes, my lord. It will be
Fresh
better.
notice. Heard Mr. H. Das, learned counsel for the applicant. No one has appeared for the opposite parties, substituted opposite parties. It appears that though name of Mr. PP Das has been shown as engaged counsel for the opposite parties, However, from the record, it does not appear that notices were issued to the newly substituted opposite parties. Hence, the applicant is directed to take fresh steps for issuance of notice on the substituted opposite parties, namely Anima Thakuria and Daisy Thakuria Das, by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Let this matter be listed again after 4 weeks. You are for
I'm
respondent.
for a respondent lordship, respondent number 1A to 1Z lordship. And last office note order to 16/9.
Mr. R.C. Paul appeared.
Yes.
Why this matter is fixed today?
For service of notice lordship. And lordship, can I see the last office order at the 16/9 lordship. Notice of respondent number 2 and 3 was not served after office number.
What is to be done? None appears for the appellant on call. Mr. D.K. Kalita, learned counsel for respondent number 1A to 1H, one small a to one small h, is present. On perusal of the office note dated 11/9/2024, it appears that the notices sent to respondent number 2 and 3, as regards notices sent to respondent number 2 and 3, no report has no report has yet been received by the registry. It appears from the office note that the notices were sent to respondent number 2 and 3 in the month of April this year. In view of above, the appellant is directed to take fresh steps for issuance of notice upon respondent number 2 and 3 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
Must.
List accordingly after 4 weeks.
Must.
May it please your lordship. Lordship, the Dusty report has not yet come. So we need some more time. Let it come after puja vacation.
Miss R.D. Majumdar, learned counsel for the petitioner, who submits that she needs some more time to
Affidavit.
file the affidavit in compliance as regards the issuance of notice on the respondent number 1 to 4.
No.
On the respondent number 6 to the scheme mode. Stop. Also heard Mr.
M. Talukdar.
M. Talukdar
For
appearing
number
for
1 to 4.
appearing for respondent number 1 to 4. The prayer of learned counsel for the appellant is allowed. Let the report allowed. Let this case be listed again after 4 weeks on a date to be fixed by
Lordship, after puja vacation.
after puja vacation on a date to be fixed by registry.
Hey, Dusty affidavit. They don't have it.
You will
Affidavit.
file affidavit after puja vacation.
Yes, sir. I'll apply.
May it please your lordship. Lordship, in this case, respondent number 1 claimant has expired, your lordship. So they have to furnish the details of the legal heirs, your lordship.
Lordship, we have already provided the details. Our they have signed, but I'm received copy to us.
Lordship, may I kindly grant a week's time, your lordship. I'll ensure you.
How many respondents are there?
Your Lordship, three respondents. Claimants, owner and driver.
Heard Mr.
H. Brother.
H. Buragohai, learned counsel for the appellant. Also heard Miss, what is your name?
Miss B Devi Lordship on behalf of Mr.
B.
S. K.
Devi,
Chaudhary.
appearing for respondent number,
One Lordship.
respondent number one. Learned counsel for the appellant submits that prays for some more time for filing appropriate application for substitution of the legal heirs of respondent number
1 year.
one. Learned counsel for the respondent number one has informed, submitted that the particulars and details of the legal heirs of respondent number one has already been furnished to the appellant.
Yes, Lordship.
Stop. The prayer of the appellant is allowed. Let this matter be listed after
A week.
2 weeks
Obliged.
to enable the appellant to take appropriate steps for substitution.
Deeply obliged.
May I please, Your Lordship, as per office note dated 30/8/2024, service has been completed, Lordship, and LCR has also been received.
Okay,
Copy of the memo of appeal yet to be received by,
you furnish it, furnish today. Heard Miss, what is your name? What is your name?
P. Hajarika, Lordship.
Heard Miss B. Hajarika, learned counsel for the appellant. Also heard Mr.
I allow.
I. Alam, learned counsel for sole respondent.
My lord.
Learned counsel for the sole respondent. How many respondents are there? Only one? Only one?
Yes.
Sole respondent. Stop. Who submits that he has not yet received the copy of memo of appeal. Learned counsel for the appellant undertakes to furnish the same to the counsel for the respondent today itself,
Yes, I have given her.
in the course of the day. Stop.
I have received it, my lord.
Okay. The office note shows that the records of the concerned cases from the trial court as well as first appellate court has been received, and this case is ready for hearing. Let this matter be listed for hearing. After 2 weeks on a date to be fixed by
After
register.
vacation, my lord.
After vacation on a date to be fixed by register.
My lord.
Yes.
Obliged.
None has appeared for the appellant on call. None, the applicant on call. Let this matter be listed after a week on a date to be fixed by register.
Your Lordship, on the last date, we were required to verify the correct address of respondent number 6. Your Lordship, we have found this address of South Sarania, Lachit Nagar. It's the regional office of HDFC Bank, HDFC Insurance Company. We would like to take fresh steps upon this address.
You have to correct the memo of appeal also, course title, where the inserting the new address
Yes, Your
in
Lordship.
the memo of appeal. And then take steps.
Yes, Your
Heard
Lordship.
Miss A. Biani, learned counsel for the appellant, Also heard Mr. G. Talukdar,
M. Talukdar, Lordship.
sorry, M. Talukdar.
For respondent number 1, 2, 3.
Appearing for respondent number 1, 2, 3. Stop. None has appeared for respondent number 4 and 5. Learned counsel for the appellant has submitted that in pursuant to the directions of this court by order dated 5/8/2024, the appellant has found the new address of the respondent number 6, that is in
Lachit Nagar.
Lachit Nagar, Guwahati. And she submits that the appellant may be allowed to take fresh steps for issuance of notice to the respondent number 6 in its new address. Respondent number 6 is a company
Yes, Your Lordship.
in its
Insurance
new
company.
address. Stop. The prayer is allowed. However, the appellant shall also file a fresh a corrected cause title of the memo of appeal where the new address of respondent number 6 is shown. The appellant is given 2 weeks time to do so. The appellant shall take steps for correcting the cause title as well as also take steps for issuance of notice to the respondent number 6 on its new address within a week, within 2 weeks from the date of this order, returnable after 4 weeks. Let this matter be listed after 4 weeks.
Much.
Formulation.
Lordship, in this case, we have to take this step on respondent number 3 in its proper address, Lordship, but we are yet to get proper address, Lordship. So some time maybe there.
What is your prayer? You need much more time.
Yes.
Heard Mr. A.J. Sarkar, learned counsel for the appellant. Also heard Mr. H. Bura Rohai, learned counsel for
Respondent number 1.
respondent number 1. Learned counsel for the appellant submits that he needs some more time to locate the proper address of respondent number 3. Stop. The prayer is allowed. Let this case be listed again after 3 weeks. And in the meanwhile, the appellant shall find out the proper address of respondent number 3.
My lord, I am appearing for respondent number 6 in this case, my lord. As per order dated, my lord, 21/5/2024, my lord, housing my order, my lord. The notice upon respondent number 5, 7, and 8, it's not completed yet. Number 5, 7, and 8. Even petitioner also not appeared before the housing. Otherwise, my lord, issue is that, my lord, the evidence of the, my lord, petitioner has been closed before the learned court below, my lord. Therefore, they approach this honorable court, my lord. Their evidence was closed.
There is no stay.
No, my lord.
Okay, none has appeared for petitioner on call. Heard Mr.
S. Hazarika, my lord, for
S.
respondent number 6.
S. Ajurika appearing for respondent number
6, my lord.
6. Six. It appears from the office note.
My lord, order dated 21/5/2024, my lord.
Office note dated 3/8/2024 that
32.
the petitioner, the
Lordship, due to some personal difficulties, my senior cannot be appear here, Lordship. The Lordship matter may be taken up after vacation, Lordship.
no, not after vacation.
Next week.
What is your name?
A. Sharma. On
Show
behalf
her
of B.
present.
Chakraborty.
Heard Miss A. Sharma appearing on behalf of Mr. P. B. Chakraborty, learned counsel for the petitioner. Then continue. It appears from office note dated 3/8/2024 that petitioner has taken steps for issuance of notice on respondent number 5, 7, and 8 through usual mode as well as through registered post with AD. However, on perusal of office note dated 11/9/2024, it appears that the notices issued to respondent number 7 could not be served due to insufficiency of address, and notices issued to respondent number 5 and 8 have not returned back. Stop. In view of above, the petitioner is directed to take fresh steps for issuance of notice on respondent number 5, 7, and 8 by registered post with AD. No, just last line, yes. Not in view of the problem, cutting. However, the notices sent to respondent number 5, 7, and 8 through usual mode appears to have been delivered to the addressees. Hence, the notices are held to be, notices to the said respondents are held to be duly served.
In that case, my lord, we do not have any objection for remanding the matter to the, my lord, court below, my lord, since the, my lord, evidence was closed, my lord. As a respondent number 6, my lord.
No, let them appear. We will fix it in the next
Since,
week.
my lord, the already the respondent number 5, 7, 8 service is complete since my lord has already, my lord, said.
No, the petitioner's counsel is not there.
Oh, my lord.
We'll fix it now in the next week.
My lord.
Let this case be listed again on on 26th September in admission column.
So government also there as deputy commissioner.
Okay, you are appearing for
Respondent
respondent,
number 1. T.R. Gogoi Lords.
Mr.
T.R. Gogoi.
T.R. Gogoi appears for respondent number 1. এতো উপরের দিকে।
2 to 4.
Anybody else?
Education department.
What is your name? Ms. K. Das, learned government advocate, appears for respondent number 2, 3, and 4. Let this case be listed again on 26th September.
I'm the privilege.
Item 44.
May it please your lordship. But in this case, I may be allowed to take fresh step on response number 2 and 3 for paper publication, lordship.
Two and three.
Lordship. Still we should take the report.
Who is appearing?
My lord, in this case, my lord, just I would like to make a submission, my lord, that the honorable court has directed to take the dusty service. Dusty, after filing of the dusty service, affidavit is required to be filed. But they have not filed that affidavit, where they have collected my lord, dusty service from the registry in the month of May. But subsequently thereafter, after serving, they will have to file an affidavit, my lord. But that affidavit is, they are not filing the affidavit.
Because that
Not-
service is not received, lordship. That is why we have not filed the affidavit. That's why I'm praying for taking fresh step in paper publication.
Service is not received means?
Lastly, service step has been taken, lordship, that could not be served. That is why we want paper.
Okay.
But in some of that I am little bit confused because they have personally opposed to that, to the opposite party.
Without serving notice, lordship, how can we file affidavit?
No, serving that is okay, but I am not understanding, man. They will have to oppose the physically to the particular
No,
person.
their submission is that when they went to, they could not serve the notice on the respondents through the mode because of some difficulty. They are not receiving. Why you could not serve?
Lordship, our investigator went to the place for service, but they could not contact them because they are not available in the place.
That's why, lordship, I'm praying for paper publication.
Because mal only one aspect. Why I'm saying that mal they are that filing the mal appeal that the petitioner is suffering. That mal the respondent number 1.
You are claimant.
My lord. So they are some in urgent need of money, my lord. That is why. Otherwise, so far the provision is concerned, they will have to communicate
Is
with
there
the.
any stay?
Mal that is the I is
There
for
is I, lordship.
condonation of delay.
You go for execution.
My lord.
You go for execution. There is no stay.
My lord.
Let them fight for delay condonation. In the meanwhile, you don't have any bar.
My lord.
Heard Mr. S.K. Goswami, learned counsel for the applicant. Also heard Mr. What is the name? This is item number?
44, lordship.
V.K. Das
My lord. Respondent number 1.
for appearing for respondent number 1 and Miss R.D. Majumdar appearing for respondent number 5. Learned counsel for the applicant has submitted that though the applicant was directed to serve the notices on respondent number 2 and 3 by Dusty Mode. However, the notices could not be served on the said respondents by Dusty Mode. And therefore, he submits that the applicant may be allowed to take steps for issuance of notice by on respondent number 2 and 3 by publication of the said notice in newspapers.
Local newspaper.
Local news 2
One, lordship. Assamese vernacular.
in local newspaper. Who is respondent number 2 and 3?
2 and 3, lordship, owner and driver.
The prayer is allowed. The petitioner shall be the applicant shall take steps for issuance of notice by publishing the same in one local newspaper circulated within the state of Assam within 15 days.
In 10 days, we will take steps.
Within 10 days from the date of this order, the date of appearance of respondent number 2 and 3 to be mentioned in the said notice shall be 4th of October. Let this case be listed again No, shall be 3rd of October, 1st of October. Let this case be listed again on 4th of October.
With your lordship. Lordship, my appeal has been dismissed twice for default. What has happened, lordship? On both the days, I was present in the court. On the first day when it dismissed, I had 5 cases from morning. I have given a cause list here. My name was not shown in both the days. My name was not shown in the cause list. It's in fact also a transferred case. There was earlier under advocate who had left for Delhi, left practice altogether. And delay was condoned by me. After it, when it was fixed for admission, my name was not shown. So accordingly, it was dismissed. When it was readmitted, again, Lordship, my name was not shown. Now, Lordship may see cause list annexure number 5 and annexure number 7. Annexure number 5, Lordship, page 22 of my year. The matter will become clear from the call.
Thereafter,
Therefore, said on the cause list annexure number 5, Lordship may see item number 8, my name is not there. But item number 13, 14, 21, 29, 45, whole day literally Lordship I was in that.
yes,
And on the next day also.
yes, you are appearing for.
Respondent 1 to 5.
You have
1 to
any
6.
objection?
So we have filed our objections.
What is the objection?
Lordship, actually, this is the 2 times already.
But his name is not shown, therefore he
As Lordship may deem.
heard Mr. R. Sharma,
R. Goswami.
R. Goswami. R. Goswami, learned counsel for the applicant. Also heard Mr.
SRA Nasir.
S.R.A. Nasir, learned counsel for the opposite party. This application under Order 41 Rule 19 of the Code of Civil Procedure, 1908, has been filed by the applicant insurance company for readmission of MAC appeal number 282/2022, which was dismissed for non-prosecution on 31/10/2022. Learned counsel for the applicant has submitted that on earlier 2 occasions also now when on the last occasion it was dismissed, when it was dismissed on last occasion, 31/10.
One is the 31/12/10/22. And the next day is order of dismissal again. I'm hearing referring to that only, 9th, annexure 1, Lordship.
Where is the impugn order?
In order is the
31.
annexure 1 and also Lordship, annexure. On this date. So there's admitted again. Annexure, cause list that is.
Learned counsel for the applicant
Annexure 6, Lordship.
has submitted that on an earlier occasion also, the MAC appeal number 282/2021 was dismissed for non-prosecution. However, on both the occasions, when the matter was listed before the court, in the cause list, the name of the learned counsel for the applicant was not reflected, due to which the listing of the said case, said appeal, missed the notice of the respondent's applicant's counsel, and therefore he could not remain present before the court when the matter was called up. Stop. On the other hand, learned counsel for the opposite party has opposed the prayer for readmission on the ground that on two occasions the petitioner, the said appeal was dismissed for default, and the ground shown by the applicant may not be treated as a sufficient ground for readmitting the dismissed appeal. Stop. I have considered the submissions made by learned counsel for the applicant as well as learned counsel for the opposite party. Learned, where is the cause list? Cause list, Mr. Sharma.
One is causes number 5 and causes number 7.
Page
Page 22.
22 is the earlier one. Next one.
Next one, Lordship, 31/10/2022.
Page
Page 33.
Where is the item number?
It's item number, it was 17. Item number 2, Lordship. Item number 2. Item number 2.
MEC appeal 282.
On that day also item number 12, 25, 34, 35.
But
As
name of the councils is shown. Mr. P.D. Nair
Nine
and
is,
Miss K. Deka.
Kedeka is not anyone from my team.
I'm for the respondent. My name is Shun.
And
My name is not shown again.
who is Miss K. Deka? K. Deka's name has been shown. She is not engaged counsel. Stop. I have considered the submissions made by learned counsel for the applicant as well as learned counsel for the opposite party. On perusal of the cause list of October 31/10/2022, which has been annexed as Annexure 7 along with the application filed by the applicant, it appears that name of one Miss K. Deka has been shown as counsel for the appellant. However, Mr. Sharma, Mr. R. Sharma, R. Goswami, learned counsel for the appellant, submits that Ms. K. Deka is not the engaged counsel for the appellant, and due to which he missed to notice the listing of the MSc appeal number 282/2221 on the said day, that is on 31/10/2022. Stop. The grounds shown by the applicant appears to be sufficient cause which had prevented the counsel for the appellant to appear before the court when the matter was called up on 31/10/2022. Stop. As the name of the engaged counsel for the appellant, Mr. R. Goswami, has not been shown in the cause list of 31/10/2022. Stop. In view of above, this interlocutory, this miscase is allowed, and the MSc Appeal number 282/2012, which was dismissed on 31/10/2022, is directed to be readmitted for hearing. The registry to list the same after readmission. After a week,
It is directed to show my.
after a week, the registry is also directed to show the name of the engaged counsel for the appellant, namely Mr. R. Goswami, as well as respondent
SRA Nasir,
SI
ASRA Nasir,
ASRA Nasir,
only SRA Nasir, Lordship.
SRA Nasir,
And PD Nair
and PD Nair in the cause list. This
Yeah, Lordship.
MC case is accordingly disposed of.
Lordship, may I pray one thing? Lordship, it is a case of, the judgment was passed by the tribunal on 2016 case, Lordship. Some amount may be released to the
Let it be listed. Let the appeal be listed.
Lordship. That may be considered on that.
On that day, you
of
make prayer.
hearing.
Let the file be before the court.
Lordship. Highly obliged.
May I please, Your Lordship? Madam sir, I'm applying for respondent number 1, 2, 3, 4, 5, and 8. And it's time to file our objection, my lord, sir.
No, what objection you will be filing in an appeal?
They want to file additional evidence, my lord, sir. Adduce evidence. With documents, my lord, sir.
No. What is the case? Who want to file additional evidence?
They want to file, petitioner appellant want to file.
That was rejected.
They want to file, we want to file objection, my lord, sir.
Or they want to file additional evidence in the appeal.
Yes, my lord, sir. In the RFA.
Where is the I? In IA, Mikhibo.
3379, my lord, sir.
I number
3379, 2000.
3379 slash. None appears for the applicant on call. Heard Miss
M. Burman, my lord, sir.
M. Burman.
On behalf of D. Nath.
Appearing on behalf of Mr. D. Nath, learned senior government
Yes, my
advocate.
lord, sir.
Appearing for respondent number 6, 7, 8, 9, 10.
1, 2, 3, 4, 5, and 8 numbers.
1, 2, 3, 4, 5, and 8. Learned counsel for the respondent prays for allowing some time to file written objection against the prayer of the applicant. The prayer is allowed. Let this matter be listed after 4 weeks
Oh, yes, my lord, sir.
on a date to be fixed by registry. In RFA main appeal, none has appeared for the appellant, Miss
N. Burman, my lord, sir.
N. Burman, appearing for Mr. D. Nath, learned senior government advocate, appears for respondent number 1, 2, 3,
4, 5, and 8.
4, 5, and 8. Let this matter be listed after 4 weeks on a date to be fixed by registry.
I appreciate your lordship. Lordship, in this case, for respondent number 3, I may be allowed to take first step, lordship, to paper of obligation.
Same case.
Same case, lordship.
Heard Mr. R. Sharma, learned counsel for the applicant. Also heard Mr. B. K. Das, learned counsel for respondent number 1, and Miss R. D. Majumdar, learned counsel for respondent number 5. Learned counsel for the applicant prays for allowing the applicant to take steps for issuance of notice on respondent number 3 by paper publication. the prayer is allowed, the applicant may take steps for issuance of notice through paper publication within 7 days from the date of this order. The date of appearance to be mentioned in the notice shall be 1st of October 2024. Let this case be listed again on 4th of October.
Wait, this is you've taken steps on the response manner. I've been informed by my learned friend, Mr. S. Chakraborty, that he'll be appearing in this matter.
Who?
Mr. S. Chakraborty, madam.
Okay.
He'll be appearing. He has informed me verbally, but he has not filed his wakalat number. So he also left, he could not come today, so he has accommodated him now.
You are Mr. Smith.
Yes, madam, for the appellant.
Heard Mr. M. Smith, learned counsel for the appellants. None has appeared for the respondent. The records of the ESI case number 3/2019 have been received. Learned counsel for the petitioner has submitted that he has been informed by Mr. S. Chakraborty that he would be appearing for the respondent, sole respondent,
Well, that also I cannot say.
respondent side. Let this matter be listed after 2 weeks
My lord,
on a date to be fixed by registry.
I'll inform him if anything may be issue.
With Lordship. This is an application for condonation of delay in filing substitution petition, Lordship.
Lordship, on the last date, Lordship, we were directed to file objection, but we have not filed, Lordship, some time may be granted.
You are insurance company.
Yes, Lordship, but other petition, we have filed objections in the setting.
No substitution, why are you opposing?
Lordship, he died natural and natural death he had made, Lordship, the victim, the claimant, the appellant. So after his death, Lordship, the case gets abated, Lordship, that is our submission.
Earlier occasion, so they took time on 15/3/2023. They took time for
No
filing
further
objection.
time.
And again, last occasion also.
We'll hear this application on the next day, next week. We'll hear this application on the next week. If before that you file objection, it is okay
On delay petition, otherwise we have filed objection.
on delay application.
So far delay is concerned, they have no serious objection.
You are not objecting.
So delay, Lordship, last date, we were directed by the honorable court, Lordship, so respecting the honorable court order, Lordship, we will file that.
No, but if you say that you are conceding, I'll also pass orders.
Lordship, that may not be proper, Lordship, as there is some direction.
Heard Mr. M. Talukdar, learned counsel for the applicant. Also heard Mr. A. J. Soikia, learned additional learned counsel appearing for the opposite party / insurance company, who prays for some more time for filing written objection against the prayer made by the applicant. Stop. One last chance is granted to the opposite party insurance company. Let this matter be listed after 2 weeks. Next week, let this matter be listed again on 26/9/2024. Before the said date, the opposite party may file written objection.
Oblations.
Lordship, in this case, I'm for the respondent appearing of behalf of Senior Mr. S.P. Roy. Lordship, in this case, we do not have the copy of the petition, Lordship, and we had searched in our files also, we could not locate. Okay,
Copy of the, whether it was served on you.
it was actually served on us, but we are not able to find it, Lordship, in spite of best effort.
Then you have to request.
Yes, sir, it's a request to get a Xerox copy of the petition copy, Lordship.
None appears for the appellant on call. Mr.
J. Das on behalf
J.
of
Das appearing for Mr. S.P. Roy.
Respondent 1 and 2.
Learned counsel for the respondent number 1 and 2 has submitted that the applicant, the respondent number 1 and 2 has misplaced the copy of memo of appeal which was furnished to them. Stop. The appellant counsel is requested to furnish a copy of memo of appeal to the respondent side. Let this matter be listed again after 2 weeks.
Oblige. May I please, Your Lordship? As per office note dated 18/7/2024, the unserved copy and the LCR have been received, Lordship. But the service report is still awaited, Lordship.
Service report on how many respondents are there?
Sole respondent, Lordship.
What is to be done? Where, what is the address?
Lakhimpur, Lordship. Lordship, a direction for fresh steps may be given.
Heard Mr. A.
Singh,
Sinha.
Lordship.
A. Sinha.
A. Singh, Lordship.
H.
A.
A. Singh. Singh or Sinha?
Singh, Lordship, in the last order, it was like
Wrongly.
wrongly stated.
Heard Mr. A. Singh. Learned counsel appearing for the appellants. On perusal of the office note dated 18/7/2024, it appears that the records from the trial court has been received. Stop. It also appears that the notices issued to the sole respondent has returned back without service. Stop. In view of above, the appellant is directed to take fresh steps for issuance of notice to the respondent by registered post with head as well as through usual mode within 7 days from the date of this order, returnable after 4 weeks. Let this matter be listed again after 4 weeks.
Lordship, kindly the matter may be come up for admission. Service has already been completed since,
You are opposing?
yes, for the respondent.
No, you are opposing the transfer.
Yes, Lordship.
Heard Miss, what is your name?
M. Bora, Lordship.
M. Bora, learned counsel for the petitioner, as well as Miss
P. Bora.
P. Bora, learned counsel appearing for the respondent. Let this matter be listed listed in admission column, for admission hearing after 2 weeks on a date to be fixed by registry.
That's it. Till then, interim may be continued, Lordship. Interim.
The interim order shall continue till next date.
Highly obliged.
Wait, please, Your Lordship. My lord, in this case, what has happened, my lord, we incorporated the name of the honor as, well, it was reflected in the claim petition. Thereafter, from the file which we have received from the company, it is seen that there was some amendment application filed by the claimant. And the policy number was changed. That was allowed also. But the judgment reflects that the honor of the name of the honor is reflected as Swarendranath Das. Now the office note reflects that the addressee has left without giving any address. But I have found a copy of policy which resembles, which is the same policy with the same numbers, which the amendment was done. The policy is issued in the name of some Dalim Chandra Devdi, and there's a different address altogether shown of Barpeta. But if my lord pleases, can I verify it with the company and let this matter come up again on some other things? Because if we take steps on this particular address once again, it will again be returned back.
Yes, because incomplete address.
Incomplete address, and there was some change in the amendment done in the claim petition. So we have to verify whether that amendment was allowed or the policy number which is being reflected therein.
Okay. Heard Mr. R.K. Bhatra,
I'm
learned
appearing for respondent number 1.
counsel for the applicant. Also heard Mr.
S.S. Ahmed.
S.
for
S.
respondent
Ahmed,
number 1.
appearing for respondent number 1. On perusal of the office note dated 12/6/2024, it appears that notices issued to respondent number 2 and 3 have returned with an endorsement within inverted comma incomplete address. Stop. Learned counsel for the petition applicant has submitted that it has come to notice of the applicant that before the commissioner, before the commissioner in what was the case, original case?
DC case number 70 of 2006.
DC case number 70 of 2006. An amendment petition was filed by the applicant.
By the claimant.
By the claimant, where some new address,
New policy numbers.
new policy number has been mentioned. And therefore he needs some time to verify from the records regarding the address of respondent number 2 and 3. Before, he also submits that if the petitioner is directed to take steps on the earlier address, it may be a futile exercise. Considering the submissions made by learned counsel for the applicant, the prayer is allowed. Let this matter be listed after
A week or 10 days.
2 weeks. After 2 weeks.
Only, it will be only with regard to respondent number 2, the owner of the vehicle. Because the driver is the same.
No, okay. Not 2 and 3, only 2.
Obliged now.
Obliged now. So actually amendment. Can I just?
No, please, Your Lordship.
What this I is for?
For allowing 80% of the claim amount, Your Lordship.
What is the percentage?
Your Lordship, that was 20 lakhs. The total compensation 28 lakhs 2,400, Your Lordship.
Lordship, the case is already listed for hearing from 2019, 7/8/2019. So my humble submission will be, Lordship, that let the matter be heard. Because we are challenging on DL. So if we pay, since the judgment was passed in 2018, so the new amendment won't come. Had the new amendment, as per the new amendment, we would have said that we are not liable totally. But as per the old MB Act, Lordship, we will have a right to recover. So, Lordship, my humble submission, let it be next week or any date convenient to Lordship or to them, Lordship. I'm ready for the hearing. Let the matter be finally heard because Lordship will peruse.
No, yes. Yes, what?
Lordship will peruse order dated 7/8/2019. When notices were served at that time, they had not even appeared. They appeared later on, I suppose, Lordship. And LCR received, so list for hearing on that day itself, 2019.
Main.
MSc appeal. 6. Seven, 8/2019.
You agree?
Lordship.
Then we are disposing on this IA. You are not pressing for it and we are giving a fixed date for
Yes.
the appeal.
Lordship.
In IA. Heard Mr. R. Chetri, learned counsel for the applicant. Also heard Ms. R. D. Majumdar, learned counsel for appearing for opposite party insurance company. This application, this interlocutory application has been filed by the applicant, praying for allowing the applicant / claimant to withdraw 80% of the awarded amount. You have already deposited.
Yes, sir.
How much?
50%. No. Direction was 80%.
Okay, 80% of the awarded amount, which has been deposited by the appellant before the registrar of this court by order dated
Order dated, Lordship.
9/1/2019, passed in IA within bracket C
33.
33/2019 in connection with MSc appeal number 6/2019. Stop. Ms. R. D. Majumdar, learned counsel for the opposite party insurance company, submits that in this case, the main appeal, that is MSc appeal, 2006 has been already.
No, MSc appeal 6 of 2019, Lordship.
MSc appeal 6 of 2019 has already been admitted and same is fixed for hearing. Therefore, he submits that instead of allowing the applicant to withdraw the deposited amount, the main appeal MSc number 6 of 2019 may be expeditiously disposed of, giving a fixed date for the same. Mr. R. D. Chetri, learned counsel for the applicant, agrees to the said proposal, said submissions, and submits that in that event he is not pressing for the instant interlocutory application. Stop. In view of the submissions made by learned counsel for both the sides, this interlocutory application is disposed of on not being pressed and on the condition that let the connected MSc appeal, that is MSc appeal number 6/2019 be listed for hearing on when do you want? Suggested date.
Pujar agot na mane pisot.
Puja, before puja.
3rd of
Third.
October.
Fine.
3rd October.
Fine, Lordship. Highly obliged, sir.
This substitution petition already some one way and one way have already appeared before this report, but he is not available. Mr. D. Dotto in Cosly's name is wrong.
No, This is for 62. Why it has come up for orders?
Lordship is 1A and 1 we have filed Okaratama after that matter was not listed before this report. For service completion of service.
Now still the office note shows that R1 to R5 notice has not been received back. Respondent number 1 to respondent number 5. There is no service report.
Already, Lordship, regarding respondent number 1A and 1B, one Mr. D. Dotto has appeared.
No, in which case 1A and 1B?
MSc Appeal 325. Supply 62, Lordship.
There is any IA? IA to nahi. Condemnation na lage. Huh? Which application you are submitting?
43223. IA 43223.
430?
223.
This is for?
This is for substitution of respondent number 1. And in his place.
Respondent number 1 expired.
Yes, the driver of the vehicle was expired. And in his place, 1A and
1A and 1B.
The substitution petition is yet to be allowed, na? Heard Mr.
KK Dotto.
KK Dotto, learned counsel for the applicant. Also heard Mr.
D. Dotto.
D. Dotto. Counsel appearing for
1A and 1B.
We have not yet made 1A and 1B. The learned counsel for respondent, learned counsel for the heirs of respondent number 1, namely 1A and 1B. This application for substitution, this application, no, this is again condonation of delay. 432
Yes, sir.
for
For delay in filing the substitution bill.
okay.
And 433 is the substitute.
And as regards other respondent number 3.
All in this case, another appeal is filed by the respondent number 3, the United India Insurance Company. That was not listed along with this MSc appeal. So both the matters were tagged together, but that was not listed today.
And in this this is 432. Yep. Orders are not properly maintained. Itu jane ki 325 or order. 325 or order to yaad like this. Main case jama. 434 or order to 432 file latas. 433 order ইয়াতে আছে 432 there is an order on 22/5/2023
That's,
it has been disposed of
yes.
432 has been disposed of
Disposed of. No, substitution was made, from my knowledge, last,
delay was condoned
yes, sir.
but this is not the disposed of case. Delay was condoned. 432 delay condoned. Then which one is the substitution application?
433/20.
433
20.
is the abatement application.
Yes. Setting aside.
And 434 is substitution. To order pass করে থৈছে 433 is also disposed of.
Disposed of.
434 is also disposed of.
I have taken steps in that respect because,
434.
yes.
434 is also disposed of.
Substitution.
Substitution petition is
That
also
was an-
disposed. Now the এইসব order sheet ভুল লাগি আছে. Now the main application pending, only matter pending is the
MSc appeal.
MSc appeal. MSc appeal or order to ইয়াত লাগিব. Directions নাই যে। Substitution petitions how? Substitution ইয়াত করা নাই। No substitution of order. এততে আছে। ফাইল তো দি দিও। আৰু order copy file বিলাকত ৰাখিব। Heard Mr. K.K. Datta in main only one case in MSc appeal. Heard Mr. K.K. Datta, learned counsel for the appellant. Also heard Mr.
D. Datta.
D. Datta, learned counsel appearing for the appearing for respondent number 1A and 1B, who are the substituted respondent in place of the deceased respondent number 1. Stop. However, it appears from order dated 22/5/2023 passed in IA within bracket civil 434/2023 that the said application was this application for substitution of the legal representatives of deceased respondent number 1 was allowed by this court. However, it appears that the registry has not taken steps by substituting the names of the legal heirs of deceased respondent number 1, that is late Kanak Hajorika, in his place. Registry is directed to do so forthwith by inserting the names of legal heirs of respondent number 1 as respondent number 1A and 1B respectively. Who else is there? Respondent number 2, 2, 3, 4 and 5.
Mr. H. Borba, because it is shown, Mr. H. Borba is again.
Learned counsel for the respondent number 3 is not found on call. The notices issued to respondent number 2, 4, 5 and 6 have not yet returned. The appellant shall take fresh steps for issuance of notice on respondent number 2, 4, 2, 4 and 5. 5 and 6 number 2, 4 and 5 by registered post with ID as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List this matter after 4 weeks.
Lordship, along with MSC appeal number 79, 2019, because that was filed by the respondent number 3. That was not listed today, Lordship.
Let this matter be listed along with MSC appeal number
79 of 2019.
79 public 2019 as the said appeal also arises out of the same case. Stop. List accordingly.
Lordship, may prefer that, Lordship, because otherwise it's very difficult to let this case, Lordship.
Noted.
Okay.
May please, Lordship. Lordship, this application is filed for releasing of 50% of the
Releasing.
Yes, sir.
We don't have any objection, Your Lordship.
Heard Mr. S. Datta. No, heard Mr. C. Sharma, learned counsel for the applicant / claimant. Also heard Mr. S. Datta, learned counsel for the
Opposite party number 1.
Only one.
Opposite party appellant.
who has filed this application?
Lordship, the claimant, me.
Okay. Khalifa. Learned counsel for this opposite party. Claim / appellant. Learned counsel for this application. Stop. This application. This interlocutory application has been filed by the claimant applicants praying for release of 50% of the awarded amount deposited by the insurance company opposite party before the registry of this court in pursuant to the order dated 5/1/2024 passed by this court in IA within bracket C number 3535/2023. Stop. The learned counsel for the insurance company appellant raises no objection to the said prayer. Hence the prayer is allowed. The applicant who are also the claimants in the who were the claimants in the MSC case number 253/2020 before the Motor Accident Claims Tribunal, Barpeta, are allowed to receive the 50% of awarded amount deposited by the insurance company before the registry stop. The registry shall release the said amount to the claimant / applicants after proper verification.
50% along with interest, Lordship.
No, in 50% along with the interest accrued.
Lordship.
50% along with the interest accrued thereon. Interest at the bank rate.
Lordship, they have the order in the I, it was ordered as 50% of the awarded amount along with interest.
Okay. How much you have deposited?
Your Lordship, 50% of 30,65,387. It will be somewhere around 15,30,000.
No, you will receive only that amount which has been deposited.
Yes, Lordship. Interest was 9%, Lordship, as part of just.
No, that is not the question. Question is whatever has been deposited by them now,
Yes, Lordship.
that you will receive. So what was deposited? Last line for you. Before that one line, eight line only. How much you have deposited?
Your Lordship, it will be around 15,32,000.
No, I need exact amount.
Lordship,
How much they have deposited? Okay. The registry is directed to release the amount deposited by the insurance company appellant to the applicants / claimant amount deposited by insurance company applicant before the registry of this court in pursuant to the order dated 5/1/2024 passed in IA within bracket C case number 3535/2023, comma, to the claimant / applicants claimant / applicant after proper verification. Whatever they have deposited, this interlocutory application is accordingly deposited. Finish.
Much.